All's good.
Okay. Good evening, everybody. We're going to call this meeting of the Laconia Planning Board to order at 6:30 PM. Could we have the roll call, please?
Sarah Jenna,
Here.
Charlie Sinclair,
Here.
Michael Bedelavecchio,
Here.
Brett Bellabo,
Here.
and Peter Burnett.
Yes, and for staff, we have Planning Director Dean Trefethen, we have Senior Planner Rob Mora, and the Recording Secretary is Kalina Graham. Welcome, everybody. The first item that's on the agenda that's Kalina so nicely put before me is PL 2019-0127. It's a continued public hearing. It's regarding 435 Union Avenue, Taylor Homes' proposal to eliminate the cul-de-sac at the end of Cottonwood Ave and create a T turnaround with associated easements. As I said, this was continued from last month, and we'll hear from the applicant.
Mr. Chairman, planning board members.
Mr.
For the
Smith.
record, Steve Smith and Associates, representing the Taylor home. I trust you have a copy of the plan I submitted.
Yes.
Put one up here on the board.
Does everybody have a copy?
Do you have a copy in front of you? Do I have to turn this, or can you leave this for the audience, or?
I think you can probably leave that for our viewing audience. We could leave that for the viewing audience, yeah.
So, I'm here tonight representing the Taylor home. We have filed an application for, I guess, amended site plan. We would like to change the cul-de-sac that's up there to a T turnaround. Over the last 6 months, I have spent time with Public Works Department and the Fire Department to resolve how it would look, how it would function, and whether it was satisfactory to them. We even staked it out and had the Public Works Department come up, and they come up with their vehicles and have no problem with what we're doing, and so the Fire Department has been in the same position. Historically, to try to just give you some background, this subdivision was part of the overall development of the Taylor home. Started back in 1987. I think it was March of '87, if I'm not mistaken, was the first application that spoke to the two-lot subdivision. And then from there through until July of '87, they were in to the planning board on 3 or 4 occasions because they were doing the congregate care facility and they were doing other residential units up there. And the two lots were all part of that. And when it came into the planning board, well, actually, Howard Chandler had written a letter or sent a letter to the planning department when Bud Young was here, wanted to come in for preliminary review of a two-lot subdivision and talked about building a cul-de-sac and deeding it over to the city. That was, I think, the letter that he had originally sent to the city. Came into the planning board for the application, same thing. Talked about doing the subdivision and building a cul-de-sac up there because the city street actually ends well short of where the cul-de-sac is now. City right-of-way.
Is that where the sign is? Some sign that says end of city maintenance up there?
Well, yeah, they just put that up there because, as you know, if the city doesn't have a right-of-way, a formal agreement or right-of-way, they no longer maintain roads. I mean, that came out a couple of years ago. There's been a lot of research going on. We have a lot of streets in the city that weren't formally dedicated right-of-ways, but the city had been maintaining them, and apparently, based on funding, Public Works can't do that.
Okay.
So they're trying to work that out. So getting back to the subdivision, they came in here, and Howard, in that first meeting, talked about the two-lot subdivision, but also said, well, we want to do more. We want to do some other things at the Taylor home. The planning board at that time, I believe at that very first meeting, gave them preliminary approval of the two-lot subdivision with some conditions on the subdivision, none of them which required the Taylor home to turn this over to the city,
Okay.
which, based on my knowledge and my experience of working here in the city of Laconia, it's not the planning board that decides whether a road gets turned over to the city or not. It's a process we go through with the planning board and with the city council makes the decision on whether they're gonna accept the road. Not all roads are turned over to the
Because
city.
they're charged with all the property of the city.
Correct.
Yes.
So they came back in on 2 or 3 other occasions with revised plans dealing with the congregate care facility, I believe, based on what I could decipher from the minutes. I did not represent the Taylor home at that time. They came back in with plans, talked about the subdivision, talked about their plans for the development. Ultimately, I think it was in July of '87, final approval was granted for the 2-lot subdivision and for the remainder of the development, the congregate care facility, the other housing. I don't know exactly what the plans were. Lo and behold, the subdivision was approved. It never got recorded at the registry. There's no plan on record of the approval. We just have minutes that we've gone back to review.
Okay.
Plan didn't get recorded. I'm guessing it didn't get recorded because that was about the time that we had the big uproar and the sheriff's department came in and locked the planning department, took all the records. And the city never got them back.
Must have been inconvenient.
It was very inconvenient.
Right.
I'm only, that's an interjection, I don't know if that's what happened, but the plan never got recorded.
Okay.
In 1987, I believe the 2 lots were sold to 2 separate parties. There was a pre-agreement. I think the Taylor home even bought the property from one of the owners that ended up buying one of the lots out of the 2. In the deeds to those 2 original lots, apparently because there was no subdivision plan recorded, the deed stated based on a plan approved by the planning board in 1986. I don't know where the 1986 came. I've researched, tried to find out where that came from. Because as far as I'm concerned, based on the evidence that I have found, this project didn't start until 1987. The initial application was March, I believe. So you have 2 deeds that call for an approval in 1986 and a plan that didn't get recorded.
Will you show me on this plan where the 2, you keep telling the 2 lots? Is it the dotted lines?
No.
Okay.
I'm gonna have to move this for you. Sorry about that.
No, if you leave it, if
We
you
have
leave
it on the
it, leave it
TV,
where it
Steve.
is, and just point to it, it shows up on our screen there.
Okay.
So, okay, if you could
You
just,
can
yeah,
see
right
it.
there, right there, right there, beautiful.
Technology is too much for me.
Now I have
Paper
to put my
guy,
glasses on.
prints. This is the Cottonwood Ave area.
Yep.
This line here represents the end of Cottonwood City Street. This line from here forward, it represents the extension of Cottonwood up into Taylor Home and the cul-de-sac. A lot over here and a lot over here.
Okay.
2 lots. The Taylor Home now owns this lot over here.
And the other one, it says Edelson, I believe.
Yeah, and the other one is owned by Mrs. Edelson.
Okay.
By Nancy. Taylor Home has purchased this lot. We currently have a gate. It's always been gated up here. We use this as emergency access. This is a retirement community. It's controlled. They don't want people coming in 3 or 4 different access points. What we wanted to do was, we want to take that cul-de-sac out, put a T-turnaround in here, and move the gate down here so it includes this lot here, because this is now part of the Taylor home. And this is area that they would like to look at using. It's a waste of area being used. They don't want to maintain a whole cul-de-sac. They believe this will be easier. The intent was to give Mrs. Edelson an easement, a written easement. The Public Works Department asked for an easement, or the city, basically, but through the Public Works, because they need to access in there and turn around.
Sure.
And we have written an easement to the Water Department, because their water comes through here. Although they thought they had a blanket easement, we've written another easement for them.
So in a nutshell, they want to make different use of the land where the cul-de-sac is currently located, or at least half the
Well,
cul-de-sac.
they don't want to maintain the whole cul-de-sac.
Exactly.
Yes. They want to bring the gate down, so this lot that they've purchased is now part of their
Correct.
community is over here and it's controlled.
Got it.
And still allow the public to use this turnaround. We're not suggesting that the public can't use it. That wasn't the intent here.
Right.
The city asked for a specific easement. We've never stopped people from coming up here and using this cul-de-sac. It's never been deeded to the city. People use it publicly. The intent is not to stop them from using that. It's to convert it from a cul-de-sac to
Sure.
a T-turnaround.
Are you ready to take some questions from our eager board members?
Sure. I'll
Charlie?
try, and I'll apologize, I only have one hearing aid, I lost the other one in the field, so it's a little difficult for me to hear, so.
Representative
Could you
St.
put
Clair?
that map back on the, please? Thank you. Can you, I'm just curious, if it was to stay just like it is with a cul-de-sac there, can you show me how they would not be able to access that property? Is it because of the gate there, or
Who couldn't access?
Taylor Home, on that lot they just bought? The lot.
Well, they could access their property.
Okay.
The gate is back here, that means
Yeah.
that this isn't part of their gated community, number one.
So it's just, it's a matter of the gate saying that the
They
gate.
can still maintain it, the city doesn't, it stops here now, they don't have, they don't come in.
I get all that. I'm just curious about Taylor Home.
Mhm.
So it's just the gate thing that is the issue with?
No, they don't wanna maintain a whole cul-de-sac, they
Okay.
want to have the T-turnaround.
And by maintaining it, it's paving it or plowing it,
They
or?
would be responsible for paving it, they're responsible for plowing it now.
And that's only happened recently because the city has said, we're not gonna do that anymore?
Yeah, because it's never been turned over as a city street.
Well, like you mentioned, there's many city streets that
I understand
aren't
that.
city streets anymore. So that's just a matter of, the city, if it stays a cul-de-sac, the city's saying, oh yeah, we'll be plowing that and doing like we do up at
No,
Wearsby.
they won't plow it.
As of right now, they won't.
Right.
Right, that could change.
Mhm.
Okay, I'm just, so, other than, they don't wanna plow it, they don't wanna maintain it, but the reality, as far as being able to get to that property and call it still in their gated community, it's just a matter of being able to move the gate down?
Right, we can't move the gate down here and have a cul-de-sac, because people won't.
I understand that, so it's, but they can still, let's say the gate, I see what you're saying. If there was no gate, and there was a sign there instead of the gate that said, private property you may not enter, is that kind of same thing as a gate?
We all know that doesn't work, that's why they have gates. They gotta control who comes in and out of this property, and they always have, that's always been the way they've.
Well, I can go up in their property, up the main
You can
entrance,
go off the main entrance,
and I'm not a resident there, and I can just drive up there, and,
that's true, but that's a controlled one-point access to come up in there for the public.
but it's not really controlled.
Yeah, it is.
Well,
Controlled by the Taylor Home.
I don't see anybody out there watching me, I just drive up there.
Well, I don't manage the property, but this is how they can manage their
I'm
site
just-
without
I'm just-
having 2 or 3 access points into their site. They have another access point, this goes all the way through to Cole Street, I think it is.
I don't know.
That's an emergency access, that's got a gate on that side.
Yeah, my point in bringing this up, Steve, and it's not to give you, to.
You're not
deb-
giving me a hard
Okay,
time.
to debate with you or anything, but it just, it makes it sound like, we have a controlled situation here, where the reality is, it's not controlled through the main entrance. Anybody can drive up there. There are signs that have speed limits, and there are directional signs and stuff like that. But I go up there quite often to make a delivery, or see somebody, or go up to the main hall for a speaking engagement or something like that. And there's nobody to say, like Southdown. Southdown has an actual gate, and I guess sometimes there's a staff person there or not checking stuff like that. And I believe they have the same thing up at the Weirs off US 3, going up into that development up there, where the tower is there. But they don't have that at Taylor Community.
Well, they have the control that if there's something that happens and if somebody is up in there and something is happening, they're only gonna get out one way, unless they break the gates.
Yeah, well, okay, I guess on that point, I get, again, I'm just trying to make a point
It's the way it's been
that,
operated for years.
yeah, no, I just don't think it's as controlled as somebody is saying it's controlled, that's all. All right, thank you. I understand, thank you.
Anyone else have questions for the applicant?
Steve,
Okay.
I don't see an after picture of what you're proposing here, like, where would the turnaround be if the cul-de-sac
hammer
is
it, yeah.
eliminated?
Right here. This gets taken out, this road continues, and this turnaround is right here.
Just a little C-shaped section.
T-turnaround, it's not uncommon,
You'd be converting a Y into a T,
Yeah, I've had them,
A
basically.
circle
I've
into,
got
Have them put a
Right.
circle, so you gotta drive in.
But see, it's, the whole circle is on their property right now, it's just on 2 lots. Because they own all the way to this line, and all they're saying is between this line and this line, they wanna get a turnaround in there. They can't fit a circle in there, so they have to discontinue the circle and put in a T, right?
that's what we'd like to do, yes.
Because you want to make better use of the lot on the other side of the gate.
Correct, and we can move the gate down here, and this can be part of our gated,
Gotcha.
or the Taylor community,
Okay.
people not coming in from the
Now,
backside.
the gate comes down here, what's gonna happen to the traffic coming up?
No, the gate is gonna be here. They're gonna move the gate up this way at the
I
end,
see, right here,
on the
right,
left
so-
side of one of the T's, right?
Yeah, if, the
It'll be
gate,
off.
the gate would go right here, right at the end of the, where the.
Where the existing road
You're gonna
is.
have a fence
Now,
going
the
across.
person using this property that wants to go use the pool at Woodside has to go out and go around and go over, to drive
Gotcha.
over there,
Right,
because the gate is here.
gotcha. Excuse me. Okay, any other questions for Mr. Smith? All right, sensing none, public hearing? Or, yeah, public hearing, okay. So we're gonna open a public hearing on this matter at 6:45 PM. Any abutters wish to come forward and be heard, please come up to the microphone, and if you would, please state your name and address, that'd be great.
Sure. Excuse me, my name's Stephen Nix. I'm an attorney representing Nancy Edelson. Nancy owns the property abutting the cul-de-sac, which was pointed out a little earlier. I've done a significant amount of research, and I put together a handout, and if I may.
Certainly.
This one has all of the exhibits on, it's 129 pages long. This one is a shorter version of it. I'll give this.
Cliff's
file,
notes.
And then I'll go over this.
Can I have the long one?
You want the long one?
Yeah, please. I promise I'll give it to Colleen at the end.
Sure. What's the long one?
Thank you, Attorney Nix. It is addressed to me, after all. I get all kinds of mail I never see.
And
Oh, that's right, you did say. I'm sorry. I stand corrected.
you know, I think I have. So the shorter version are the first few pages of the document. The first document is dated today. It's the cover letter. After that is a chronology of the events regarding the Taylor home going back to 1987, some of which Steve Smith covered. But what I've done is put them in chronological order and then included the documents in the large handout. The third document in here, labeled Exhibit B, Exhibit A, is a letter that I sent to Steve Smith on November 1st, which covers some of the issues I'll cover tonight, and in lieu of reiterating at length all of what was in that letter, I simply attached it to this document. And what I'll do is go over this, go over the main issues here. Some of what's been represented regarding the ownership of the property out here doesn't follow what the law in New Hampshire states. And I'll give a brief introduction. RSA 229.1 in the local road section of the statute say that there's 4 ways that a public highway can be created. Either through the layout process on a piece of property that's owned by the city, think of the road to the dump, by dedication and acceptance, and by prescriptive use, which is use by the public for 20 years prior to 1968. In this case, what Nancy Edelson is arguing is that the approval of the plan in 1987 that created this cul-de-sac was the dedication of the cul-de-sac to the public. And I've cited the case law in here. The Plonsky is the main case on that, and it's been the law for 150 years in New Hampshire, that when a plan, a deed for a lot conveys, and it calls for the plan, and the road is shown on the plan, unless there's express language in the deed or on the plan stating otherwise, the presumption is the road is dedicated to the public. And so then the question is, well, what does that mean? What dedication and acceptance is a process where the owner of the land essentially waives any claims to damages for the town to take that road over. It is also a way to open that road up to the public. Now, the second part to make it a public highway is the acceptance part. And Steve has indicated that originally there was supposed to be a deed from the Taylor home for the cul-de-sac, which would have been the express acceptance if the city council had accepted the deed. That didn't happen. We haven't seen that. But there's another way for an acceptance to take place, and that is through the implied acceptance. And implied acceptance is when the municipality, in this case the city, and the public use the dedicated road for a long period of time and treat it as if it's a public road. Nancy Edelson has indicated to me she's been there since 1994, and the city has plowed and maintained the road. They've kept up the pavement. They've otherwise maintained it. The public has been using that road. There are other folks who live on the road who have lived there for a very long time, and they will state that the city and the public have been using the cul-de-sac since it was built sometime in either late '87 or early '88. That action by the public and by the town is enough for that cul-de-sac to have been accepted through implication, which means there's a few legal issues here. One is, let's say that there was no acceptance by implication. Let's assume that. The dedication is very clear. It's described in the deeds. The cul-de-sac is described. There's evidence in the record, which I've given you, that this was approved by the planning board and it was required to be a cul-de-sac. So the dedication is there. There's other plans I'll put up in a moment that the Taylor home throughout time, in the late 1990s and 2000s, put on record boundary plans of their property, and they showed the cul-de-sac as being part of Cottonwood Ave, not part of their property. So under under the statute, once the road is dedicated to the public, the only way that dedication can go away, and let me say, once it's dedicated and not accepted, under the statute, the only way that dedication can terminate is through a vote of the city council. That's what the law is. The road was dedicated. That dedication exists. There has been no vote of the city council that has terminated that dedication. That's one part of it. The second part of it is, through the actions of using that road for a very long period from 1987, 1988 to the present, the public and the city have implicitly accepted that road, and it is in fact a public highway. And in order for that public highway to be discontinued, would require a vote of the city council.
Steve, just a question.
Sure.
What is the legal difference, the significance between the two things, acceptance and, what'd you say?
That's, well,
Dedication. In other words, you said they only did the dedication, but they didn't do the acceptance. What changes when they accept it legally?
when the dedication, it remains a private road, but dedicated to the public. In other words, it's not a public road.
Doesn't affect fee, doesn't affect title.
No, the fee title is not affected. Thank you for asking that question. The fee title, which is the ownership of the soil under the road, the presumption in New Hampshire law for 250 years has been that the abutting property owners own to the center line of the road, and on a cul-de-sac, they would own their piece of the pie. They own the land underneath it as soon as their lot is conveyed.
Okay.
And so the dedication, and let's back up this. when the lots are originally conveyed, very rarely has there been a dedication, and very rarely has there been an acceptance when the lots are originally conveyed. Not enough time has passed. City council probably hasn't taken a vote. What happens is, under private property law, and I cited the cases in my letters, under private property law, the owners of the lots that abut the road, in this case the cul-de-sac, have an implied easement to the entire road that services their lot. So this is a little bit of a different argument, but Nancy Edelson, regardless of what the public rights are, Nancy Edelson owns a private easement right to that cul-de-sac, to the entire cul-de-sac, under New Hampshire common law. Once the acceptance process has occurred, either through express vote or a deed, so that's a lot of municipalities will ask for a deed, and that is in effect the acceptance, or through long period of time, the implied acceptance. Once that occurs, it becomes a public highway, and the public's rights then overlay on it. The private easement rights don't go away. They're underneath it, but the public rights are overlaid on it. That's the situation we have here. This cul-de-sac is a public road, and through implied acceptance, if it's not a public road, the abutting property owners, especially Nancy Edelson, own a private easement right over that. What hasn't been said here tonight is why this is occurring, or I didn't hear it, but my understanding is the underlying purpose for doing this is to decrease the building setbacks so more buildings can be constructed in this land. And I didn't hear that expressly stated earlier, that's what's going on here. So what we have is a conflict between the property rights of the people out here. There are other issues that I included in the letter that are not within the planning board's jurisdictions. They're completely private issues of adverse possession of some of the properties, as well as the ownership of the shade trees. I included those simply to get them in the record, and totally understand that the planning board doesn't have jurisdiction over any of the private issues.
Thank you.
It is my understanding that the city, in fact, plowed the road during this last storm, if you call it a storm. It got us all to put our plows on anyway.
Well, the plows were out.
Yeah, the plows were out. So, the city did, in fact, plow it as they went around.
They didn't plow it as they went around?
No, they did.
They did.
They did, I'm sorry. Yeah. And again, so if I want to show something, how does this work?
Put it right up in over Steve's stuff. If you want. No, probably,
You want to use what he's
you
got
want
or
to use
something
that
else?
too. Put it to the left perhaps if it is, and can we pan the camera? Of course we can. Karina can do anything. Pan and zoom, pan and zoom. Right on the back of Steve's head.
That's not a good thing.
Yeah, I know, the glare hurting you back there, yes, sir.
I'm the last male in my generation to suffer this.
That's okay.
I'm gonna put that out there in my family. This is I believe this is 1991 plan that is labeled boundary plan for the Taylor home. And the boundary shown on here indicates that the cul-de-sac is not part of the Taylor home property. Did I get the right date on that?
I can't even read it, I'm sorry. What'd you say, 1991?
91?
Yeah, I had to couldn't see it from back there. Can you tell me who stamped this? Am I looking at that right? That's an engineer stamp?
That's an engineer stamp.
Well, the engineer doesn't have any right to do boundary work in the state of New Hampshire.
What I'm doing is showing the plans, a series of plans that were approved by the planning board. This is what was represented by the Taylor home. This is
Sure.
a 1989 plan by Riss Frost, stamped by a licensed land surveyor. It says boundary site plan, and I've highlighted the area on that plan where the Taylor home has indicated that the cul-de-sac is not part of their property. This is a plan that was done in 2000 by Steve Smith's office that shows that the cul-de-sac is not part of the Taylor home property. It does have a dashed line right here, which is a tie line between the two, but it indicates to see note 10 on this plan.
Those have exhibit names on them? Are they exhibits in this
They
document?
are exhibits, yes. Actually, that last one is towards the end. I think it's the next to the last exhibit.
What's the exhibit names on the backs? Maybe double-sided. So that's why that one's not labeled.
Is it in there?
I'm looking. You went all the way to Y.
Well,
so-
it's just before Y.
There's one that doesn't have an exhibit name on it. Maybe it's it's the notes.
Yeah, that's.
So that's exhibit X,
There's,
survey of land.
that's all one exhibit. There's three plans in there. That's the title page, and you flip that one over.
Oh, I see, it's two-sided.
Yeah.
So what, we would read that this way, then, basically. There's the plan, there's the notes. Note 10.
Yeah, and so what note 10 says is, according to the Laconia Planning Board minutes, the cul-de-sac at the end of Cottonwood Ave was to be conveyed by the Taylor home to the city of Laconia. Excuse me. No record of transfer was found. Layout of the cul-de-sac is based on reference plan H and BB, which we'll get to in a minute. These minutes also grant approval to two building lots, one on either side of the cul-de-sac. One is currently owned by Claude D. and Gladys and Plummer, and the other is owned by Nancy Edelson. So, and if you go to, at the end of the little table, I printed out these two notes. There's a table there that has all the dates and everything. And note H says that, that the plan was the Taylor home, Laconia, New Hampshire, Taylor Retirement Community Subdivision, which matches the description of the plans in the original deeds out back in 1987.
Were those notes H and I that we're looking at, or H?
It was H, correct?
H is, it's a reference to the Taylor home. The
Right.
plan, subdivision plan. Rist Frost Associates, dated June 1987, not recorded.
Right, so.
Steve was talking about.
Right, so this would indicate that in 2000, when this plan was drawn, somebody had a copy of that plan, because that's how they created the meets and bounds of this. That's
Got
basically
that.
what the note says.
Okay, thank you for that.
So, that covers the presentation I wanted to, there's a lot of information here. I'll take questions, but Nancy Edelson's position is that the Taylor home does not have the legal authority to do this, based on both her private property interests in an easement for the cul-de-sac, as well as the dedication of the cul-de-sac and the implied acceptance of the cul-de-sac and it being a public road.
Okay. Are there any questions for Attorney Nix? Yes, Brett?
So since this acceptance was implied, what legally would have to be done to roll that back? Since there was never a vote on it or paperwork done on it, how if it's proven that this should be their property, how do they roll back that implied acceptance then?
They would have to go through the discontinuance process, which would mean a hearing, a petition to discontinue the highway, and a hearing at the city council and a vote of the city council.
Because to me, if the city has gone out there recently, from what I heard, and put a sign up saying that, hey, we're not gonna maintain this, that's almost an outward sign of the city saying, we don't want this road. We don't want to be responsible for it.
Putting the sign up, I don't know who put the sign up, but putting the sign up, it does not legally discontinue a highway. It has no legal significance, except as just evidence.
So is there any prescriptive use here, prescriptive title conveyed by the continuous use of it as, by the public, for example?
Well, prescriptive use by the public would fall under the prescriptive creation of a highway under 229-1, and that's limited to 20 years before 1968, which means it would have had to start in 1948. So by law, it can't meet the criteria for prescriptive rights. But it does for, that time period doesn't apply to implied acceptance.
Gotcha. Any other?
Mr. Chair, if I may just point out to my fellow member over here, maybe you're aware of this. This is not a problem of somebody putting a sign up saying we're not maintaining this, we're not responsible. That is unique to this part of the city. This is going on in a lot of places in the city, much to the horror of many residents that live on these potential streets that are now trying to be abandoned by our Public Works Department for whatever reason. So several of these have come before the city council with spirited debate from representatives of those residents, their counselors, and the residents themselves. And I'm not sure, and Dean might be able to clear this up, but I'm not sure that it's always happened that these roads have been abandoned. If nothing else, some of them have said, well, let's wait and do a little more research on this. In the meantime, the city will continue to provide services, whether it's plowing or trash pickup or whatever. Because there are a lot of questions to be asked about this. And if I was a resident on a street where I either bought a home or built a home, more than likely up in the Weirs area, you bought a home, and you're paying taxes, and all of a sudden somebody comes along and says, well, oh, by the way, we're not going to maintain this street, we're not going to provide services that we're doing all the rest, around the rest of the city. The first question I'm going to have is, was my tax rate going to reflect that? And I already know what the answer is probably going to be. So I'm not impressed at all if somebody threw a sign up there. And probably by you saying that somebody just plowed that recently, probably somebody's going to get in trouble for that. I don't know.
Well, no, but I think that's the thing. The road was never formally accepted by the city. That's why the city can put up a sign saying we're not responsible for this.
And I get that, but, you know, it may not have been formally accepted, but they sure as heck have been treating it like it's been accepted all these years by maintaining it, by paving it and plowing it. So maybe somebody didn't sign the thing, but I would think I think that's called adverse possession in some cases where somebody doesn't respond to something and they just let it go like it is.
Well, that's the prescriptive use that we were just talking about. And it
But
doesn't
it's
apply
a
to
similar theory that.
Similar theory.
Similar theory over a long period of time if they've used it, the dedication. But what happens is,
Does acceptance convey the fee?
no,
Okay, so the city council could vote to abandon it, you said. They could vote to reconsider their original designation of that, couldn't they?
well, the city council didn't originally designate it. The planning board has the jurisdiction to approve the
Gotcha.
plan, which creates the dedication. The planning board can't accept it, but the planning board can dedicate it. And in this case, there was a part of the planning board process. Let's go back to 1987. I think there's a few of us in the room that were actually
Yes, let's go
around in
back.
1987. And
There you go.
Yes, please do it, take me there.
and I included the planning board subdivision regulations from that time period in the package. And if you, when you read those, you will see that in that time period, the planning board process was a two-step process. You first applied for preliminary approval, and you went through the preliminary subdivision process. You worked with the planning board, and once that process was finalized, the planning board would, in this case, the site plan review committee would give a preliminary subdivision approval. The next step is to bring in the final plan, and I forgot whether it's 6 months or 12 months that you have to bring in the final plan. And then the planning board reviews the final plan to make sure that it meets all the requirements of the preliminary approval, as well as final approval for recording, et cetera, and then you get your final approval. In this case, there was an express condition in the preliminary approval that required the cul-de-sac to be constructed. The process went on through the planning board. It was, with the Taylor home, it was parallel applications. They had the application for the two-lot subdivision, and they had the application for the planned unit development. And they didn't start at the same time. The subdivision started first, and then a couple months later, the planned unit development started. But what happened was let me get my dates right here. The subdivision process obtained preliminary approval first, then the planned unit development obtained their preliminary site plan approval, and then there was one public hearing for both of those in April in July of 1987. Both those applications came together in one planning board meeting, and they were both approved at the same time. They actually had the public hearing the first meeting, and then a couple weeks later, they had another meeting and approved it.
Now, do you and Mr. Smith agree that the plan that he put up there is the plan that created an obligation on the part of the parties, and or created the original, led to the original designation? Is that what it was?
Well, I don't know what.
You have to clarify that.
Well, I guess what I'm getting at is you have an exhibit that seems to be identical to what Mr. Smith put up there. There is planning approval that went with that plan, but that plan was never recorded,
That's
right?
correct. That's correct.
Did that approval require Taylor Home to convey the property
Yes.
No, it did not.
and construct?
Well, it did. The preliminary approval, which is part of the planning board process, required it. Not only that, but under the law, in the case of the 1808 Corporation versus the Town of New Ipswich, which is a relatively recent case in the late 1990s, I believe. I have it cited in here. The Supreme Court of New Hampshire went through a similar process at a zoning board meeting, and they went back through the minutes of the meeting and determined that the applicant had many times made certain representations to the board. Those representations did not become written requirements for approval, but the Supreme Court said, in the context of land use planning, local land use planning boards, if the applicant is making certain representations to the board, those representations become a condition of approval. I have listed in this chart multiple times that the Taylor home represented to the planning board that they would construct this cul-de-sac and deed it to the town. The documents supporting those representations are in the handout that I gave you. It's in writing. So under the 1808 Corporation case, it is a requirement of the approval. And that requirement has not gone away. Simply the passage of time, there is no law that says that a requirement of a planning board subdivision approval terminates after a certain time. So my client would argue that the Taylor home is under an obligation even today to provide that deed under the
Uh,
subdivision conditions.
I think Mayor Leahy agrees with you on that. I mean, in the paperwork that I
It-
read.
yeah.
He seems to say that there is still an obligation to convey.
Right.
Okay. Well, so she would oppose obviously the closing of the cul-de-sac and its replacement with a hammerhead, right?
That's correct.
Okay.
Yeah, and I want to get it in the record that from a planning standpoint, not just a legal standpoint, but from a planning standpoint, this is not a better solution. This is and I'll call it the hammerhead even though it's a Y, because that's generally what we call them. The cul-de-sac is a better situation because people don't have to turn around. They can circle around. If you get a large truck up in there, tractor trailer, they're going to have to back out. That's not going to work for them.
They were definitely misled by GPS if they're up there.
Yeah, well, it's like going up Belknap Mountain Road to get the gun
We're
started.
making a delivery.
Are there
Yeah,
any other,
if they're making a delivery.
are there any other questions for Attorney Nix at this time? Okay, so why don't we hear from some other abutters? And we'll get this thing sorted out tonight, if we can. Staff looks hopeful. Good evening, Mr. Mayor.
Prior to the November meeting, I had handed out a packet. I don't know if everyone still has that. If not, I brought extra copies that I can give you. And in addition, tonight I have a supplement.
We'll share. Thank you, Mary Lee.
Oh, my God, it's rare.
You're up to page 25.
Thank you.
That's the page 25. I ran the numbers. Does everybody have the first handout that I did?
You do that?
Yes.
Yes.
Yes, we do.
That's it.
The one dated October 30th.
That's correct.
Yep.
First of all, as.
And the record will show that the one handed in today has today's date, December 3, 2019, and both of them are letters addressed to me as the chair. Thank you.
First of all, from a planning standpoint, as I indicated in the first memo, I'm a 60-year resident of Cottonwood Ave. So I've lived in the same house except for 4 years when I was away at school. So I'm very familiar with the history of that street, what goes on in that street, who does what on that street. I can tell you that all week long on that street, there are FedEx trucks, telephone company vehicles, UPS, the garbage truck, anything you can imagine, up and down that street, and they all use that cul-de-sac. If you want to create a mess on that street, do away with that cul-de-sac, and you'll have reached your objective. It would be terrible. I haven't heard anybody say anything about the fire department. I can't imagine that a fire truck is gonna wanna try to go on this hammerhead turnaround and do a 3-point turn and try to back out of there. I've seen that fire truck with some of our elderly residents go up that street many times, as well as the ambulances. It would be an absolute disaster. What I did in the first memorandum, which was October 30th with the attachments, I simply went back and looked at the town ordinances that dealt with the subject matter and your own regulations. And what the conclusion I come to is that cul-de-sac then, in 1987, and today, is required. That's ordinance 197-8. Even under your own regulations, I'm not going to quote them all, but on the bottom of page 2, you'll see the citations that cul-de-sac is required. And that very smart planning board back in 1987, when Taylor Home came forward and wanted to do their planned unit development and this 2-lot subdivision, they saw an opportunity. which is the golden rule of planning. When you have something that's non-conforming, let's try to make it conforming. And they saw an opportunity. And they said, you want to do that? You're going to build a cul-de-sac. For that, there's actually two streets. Walker Street comes up,
Yep.
and then Cottonwood, and measured it, I think it's 1,500 feet. It's well over the,
And I never knew that till last week. I thought Cottonwood started at Butler.
yeah.
Until
no,
I noticed the sign, because
No.
I used to deliver papers up there. I called it Cottonwood,
Right.
so. 2
So-
cents a paper, boy, that was a lot of money.
That looks like, that's what happened.
Yeah.
And that cul-de-sac has been there ever since. Yes.
You said plan unit development, what the original subdivision was to allow Kaler Home to do a PUD in there?
As was said, they kind of did it together.
And that increases the density that they could build, right? Is that what the planned unit development was?
I don't think this subdivision had anything to do with the planned unit development, but when you read the attachments and Howard Chandler's submissions, it kind of came forward at the same time,
Okay.
okay? But the subdivision was separate, the cul-de-sac was definitely required. Since that time, used by all those vehicles every day that I've described. The plow goes up around, the city has plowed it, so we're talking about over 30 years. Over 30 years, that's what's happened.
Have you talked with your neighbors about all this?
I've talked to my neighbors. There would have been a lot of neighbors at the November meeting that were concerned about it. I'm not sure if, they don't get
I
the
think
second.
they came and we sent them away, didn't we?
Yeah.
There were some people.
Yeah, there were some people here. They're concerned about it.
So,
They use it. They use it.
okay,
Because and I'm gonna go back to, Steve kind of smoothed over an issue in his presentation. If you look at the application, it's proposing an easement for Public Works and an easement for Nancy Edelson. But then he says, well, the public can also use it and, blah, blah, blah. If it's open to the public, Public Works doesn't need an easement because they're a member of the public. And Nancy Edelson doesn't need an easement because she's a member of the public. Everybody else is going to be locked out of that cul-de-sac, out of that turnaround, whatever it is. And it's going to be, you're going to have fire trucks turning around in somebody's driveway, or FedEx trucks.
have
That's
you
what-
seen Attorney Nix's letter and the attachments?
I'm sorry, I didn't.
Have you seen Attorney Nix's letter and the attachments that he just spoke
I
of?
just saw it, I have not read through it, but
You heard what he said, though? Do you agree with
what he
his
said about what?
interpretation of the rights of the Edelson Trust?
I guess in terms of the center line and so forth, my bigger interest is certainly that cul-de-sac was required then, and it's required today under your regulations. As I cited in the first memorandum, there is a real question under your own rules whether or not this application can even be considered this evening. And that's under Section 8B, which talks about modifications and amendment of approvals.
So you mean we didn't properly notice it if we intend to modify the 1987?
Or whether or not you can even consider it, because what your own rule says, there has to be evidence that in 1987, that planning board reserved to itself, which would include future planning boards, the right to amend that plan.
But all of approvals are conditional, aren't they? I mean, if there was a condition that had to be complied with,
Oh, you can, it's enforcement, yeah, it could be, it could be enforced by the city.
so why
But in
don't we
terms
have
of-
the implied right to change the conditions?
I don't think you do, no.
We have to sometimes just to enforce these conditions, don't we? If we find that a condition is unenforceable and it affects the rights of the abutters, why couldn't we modify it?
I don't think, under your rule, you can't, because what's being proposed here is changing what's there. taking a cul-de-sac, which is required, it's not a hammerhead that meets this.
It looks like a Y. They're not gonna change that?
What they want is that where you come in and make a three-point turn. You come in, you take a right, you back up,
I assumed it
and you
would be
go.
a T and not a Y, that's all.
Yeah.
Didn't,
but
didn't see it on the
The
plan.
rules then and now are, it's gotta be a cul-de-sac.
Okay,
And what I'm saying is, they're proposing now, 30 years later, something else with no evidence that there was ever reserved the right to do that, and therefore, it should not be done.
any questions for Mayor Leahy?
I have just a couple other points.
Oh, okay.
On the issue of, well, the property was, there wasn't an order that the property be conveyed. I covered that in the second submission. And the best evidence is from Steve Smith himself, who in 2000 embarked on an exhaustive review of the planning process of the Taylor home, looked at all the plans, read the minutes, did everything else, and that's note 10 that Steve next read to you, where he says the planning board minutes indicate that Taylor was supposed to convey that property.
Steve, you wrote note 10?
Did I?
Yeah.
My office wrote it, and when I have time to respond to it, I will.
Oh, I know you will.
If you look on page 15 of that, of the second submission, 15 and 17, you now see the deeds that go to Norman and Bing Plummer back in 1987. And I highlighted the areas where they talk about the sides of the property, each of the properties that abut a cul-de-sac.
Is Amended the predecessor to Edelson?
Yes.
The same lot?
Yes.
Okay.
Yep. And of course, the deed, I assume drafted by Taylor Home,
Right.
describes the boundary as being Cottonwood Ave, which is the cul-de-sac. It was clearly part of Cottonwood Ave.
Where's 71 Walker? On the corner?
Where is what?
71 Walker.
71
It
Walker.
says, it identified
71
Paul's
Walker.
address as 71
That's where he
Walker.
lived. That's where he lived.
So down the street.
Yep.
And he bought an additional
He
lot.
bought that, and his daughter and husband built a house there. And then Bing Plummer built the house on the other side.
Did you bring them over some baked goods to welcome them?
Yeah.
I bet you
So
did.
in each of the deed drafted by Taylor describes the property on both deeds as the boundary being Cottonwood Ave, which was along the curve of the cul-de-sac. I mean, it's clear that that's what they knew they were doing. As recently as this June, page 19, now Taylor, represented by able counsel, I'm sure, and fully engaged now in the planning process, accepts a deed from Gail Bean for the lot, the house that was pointed out to you, and it's got the same deed description. And that is that
Along the westerly right-of-way of Cottonwood Avenue on a
Cottonwood
curve
Avenue.
having a radius
I
of
mean,
100.
come on, who's kidding who here?
So the curve with a radius of 149 and 18/10 is the cul-de-sac, right?
Right. The city, so if you go to page 21 of that document, page 21, this is Wes Anderson's memorandum to to Scott Myers, talking about the history of this. Clearly, the city's position is that Taylor was obligated to convey that property. It says so right in there, and they tried to get them to do it repeatedly, and they would not. As I indicated in the first memo, I'm very disappointed that instead of enforcing this planning board's order from 1987, The city chose to kind of abandon the people on Cottonwood and put a sign up there and say, no city maintenance. I mean,
But
that's
they
not,
continue to plow the cul-de-sac because it's a more convenient, easy way to get
they
it,
go,
turn
I'll
around.
tell you today, I saw a Taylor home truck plow that, or go up around that cul-de-sac today. But in the past, for 32 years, you never saw a Taylor home truck plow that cul-de-sac. Why? Because it wasn't their property and they weren't obligated to do that. It was city property. And not only would the city go up, because I'm out there shoveling or running my snowblower myself, and I see the truck come up and I'm waiting for them to come down and leave me a big, ridge.
Yeah,
But they're up there a while. And that's because they're cleaning up and making sure that the two houses have access, and then they come down. Taylor Home never did that. The city did
two
that.
houses have access off the cul-de-sac.
Yeah. Two-
So if they if it was converted into a T or Y, it looks like they're just cutting the circle off, right? That would create a Y. Like a U.
If they did that,
A U with a tail is a Y.
if that happened, you would violate your own ordinances and regulations.
Well, we
Because
can't do that, Ken.
Because it's ordered to be, it's supposed to be a cul-de-sac. Lastly, on page 22, on this issue, the city's tax map, Taylor's tax map. What does it show at the end of Cottonwood? Come on, it's part of Cottonwood Ave. It's not yellow, it's not part of the Taylor home.
It follows the radius.
So, why are Taylor Home and the city of Laconia for 32 years acting like that city property? Well, if you turn the page from the map, on page 23, you'll see it. And it's Howard Chandler's initial submission. This is what the Taylor Home proposes.
Wow.
To build it to city standards and to convey it to the city.
And that was the cover letter basically to
Yeah.
their
And then when he
1987.
went in and testified, if you turn the page on page 24, and I've highlighted it,
Okay.
he made the initial presentation. This is in March of 1987. Mr. Chandler advised that the cul-de-sac would be to city standards and conveyed to the city.
Is that the minutes?
That's the minutes, yeah. And that's what Steve Nix just said. He cited you the 1808,
Gotcha.
the case. That's a clear representation. What happened after that, what Steve or somebody is going to say, well, it didn't say anything about conveying it in the subsequent minutes as the process moved along. You know what the answer is? It didn't have to. It didn't have to. Because if you think of it logically, what's the only reason that a municipality can tell somebody you have to build a road or a cul-de-sac to standards? Because it's going to become public and we're going to take it over. So after that March 1987 meeting, what you saw in either every presentation or every planning board order was, it will be built to city standards, which is code language for because the city's going to take it over and it's going to become a public street. That's what the answer to it
The
is.
approval seems to say that the city was supposed to design the cul-de-sac and approve it.
Yeah.
That highlighted.
Designed it, and then Taylor constructed it, that's right. Yeah, they
So
constructed
they had to construct it to the design that
Yeah.
the
it to meet our city standards.
Public Works design, okay.
Yep.
All right,
Mr. Chair,
yes,
I have one question.
Charlie, sure.
Matt, when you said you were disappointed, I think that's the term you used, about the city not recently, at least not enforcing who in the city are you talking about? Are you talking about the city council? Have they
No, I'm
discussed
talking about the
this?
city administration, taking a move to either deed that property over like you were supposed to, or do it legally
But
to enforce
I
it.
just want to be clear, because like I said, this is not this neighborhood. When you say there's a lot of departments, is this Public Works? Is this the city manager? I mean, who? do you have, is there somebody, I mean, where did this come from? Public Works? This decision to put a sign up in, because I go to city council meetings all the time, or as much as when I'm ever at home, and I don't remember, unless I
Having been
missed it, I don't
involved in
remember
the
this coming
government,
up.
having been involved in the government for a long time, I would say that was probably a city manager in conjunction with
Public Works.
Public Works.
And why was,
Even planning.
why do you think it was done? The sign?
Because when I inquired about it to Scott Myers, that's the response I got, that there was this issue and they-
Well, was he trying to say that we don't?
oh, I don't think so, no, and it was mostly by email, so there wasn't, a big explanation, but it was, when I delved into it, then I saw that this was an issue. I came over and looked at the city files and so forth.
So I have a question for you. So, do you agree that the public has a right-of-way in the cul-de-sac right now, as laid out?
That the public does?
Yep.
Yes, I believe that's
Can the
city
city
property,
council modify that?
and that it can't be modified. I don't
Okay.
think that can be modified.
Okay. That's a good answer.
Well, I don't think it can be modified legally. Obviously, you can do anything you want, but if you do that, and I've included the ordinance right in the first submission, page 8, and then your own regulations. Page 11. Your own regulations say that it'll be designed to city standards. The city standard is at 197.8, that requires a cul-de-sac.
Gotcha.
Yeah, so 11 says city standards, and that's it.
I'm impressed that they pluralized cul-de-sac properly, too.
How did they do that?
Sorry,
Yes,
just the way my brain works. Okay, any other questions for Mayor Leahy? All right, well, sensing none, perhaps we could have another abutter come up and address
Okay.
this issue.
thank you.
Thank you for your presentation and your paperwork. I'll add it to the pile. Would any other abutters care to come forward at this time? Are there any other abutters that would like to discuss this? Any members of the public? No? Going once, going twice. We'll close the public hearing at, what is that? Be my eyes, 7:30.
7:37.
Thank you very much.
Chairman, can I respond to,
Yes, yes, you may.
you closed the public hearing, can you open it back up so I can respond?
Do we want to hear from staff first? Would that be more helpful? Before, you can go
I
last?
want to have a chance to respond, that's all.
Okay, we'll reopen the public hearing. Let the minutes show that we've reopened it at 7:38, and we have invited Steve Smith
Thank you.
to return to the podium.
I'm not going to speak to the legal issues, because they are exactly that, legal issues. There's, conjecture about what law says and what case studies say, and that's for the courts to decide, and that's an issue between property owners, not the planning board, as far as I'm concerned. So I'm not going to try to address any legal issues. I'm not going to take over their jobs. That's not my job. We did meet with the fire department. The fire department has no problem with the Y turnaround, if you want to call it a T turnaround, that we've represented. We have other designs other than cul-de-sacs that are allowed by Public Works Department. They have standards, they've given them to us. We've designed them for other subdivisions in the city. So cul-de-sac is not the only type of turnaround.
Are you planning on just cutting the circle into a Y and leaving it the way it is?
Yeah, this is what we're gonna leave for
That's
the
what-
turnaround, and this is what the Public Works has approved.
And the fire?
Yes. We talk about tax maps, property lines. Tax maps are not used for property lines. They are general information for taxation. That's the purpose. That's why they're called tax maps. So not sure we can have any weight on tax maps
I
in
think you're right on
themselves.
that.
That bothers me a little bit. In terms of my interpretation on the plan that was brought to your attention, that is part of an exhaustive survey, and I don't remember, there's 8 sheets involved in it. It's an alt-title survey. We're required to note anything and everything relative to property on a title survey. That was one of those pieces of information. We aren't the ones that decide what the information is, and if it's good, is it bad. We have to put it on the plan. It's up to the title attorneys to take it from there.
Correct.
We're not taking a position on that. That's something that's required when we did that survey. We have those minutes. Those minutes are the ones that I have in my possession. There's no condition on that in terms of this being turned over to the city. Yes, Howard talked about it several times. I've come in here and talked about turning roads over to the city. That's not how it's done. Subdivisions are done every day around here. Roads are built. They stay as private roads until they're petitioned, the owner's petition, or the developer petitions the city to take it over when there's enough houses built and the tax dollars are coming in. There's a process for that. Not all roads are turned over to the city, but all roads that are built for subdivisions, built for site planning, are built to city standards. That's the requirement. That's what we design to, regardless of whether it's going to be conveyed to the city or not. So this road was built to city standards, just like every road that we design coming in here for subdivisions and site planning. We have a standard on a design, and that's what we use. And it basically follows the city standards. I don't know if, Mike, if you want to get up there. We have Taylor Holmes' attorney here, too, who has also been working on this, and I think she would like to say
Sure.
something.
Before, I have a
Oh.
question.
Yep.
Before you
Oh, yeah,
start,
I do
Steve.
actually too.
Steve, I understand what you're saying about a lot of these homes are built to city specs and private developments. But does the city automatically go and start plowing those places?
But that's,
The
they've
city
already done
tried-
that. That's not my.
No,
I mean,
I'm asking you, if, when you represent a development and they build this roads to spec, but they're still in a private development,
The
are you
town-
aware that the city goes in and starts plowing immediately? Why, it's still owned by the development?
No,
Okay, I'm just curious, because
no, I didn't say that.
no, I know you didn't say that. I'm bringing it up because you said that these places are built to city specs. That's pretty common.
Well, that's a standard requirement. under the
Sure, I get
regulations.
that, and I agree with you on that. But my point is, I'm just trying to point out that this cul-de-sac has been maintained by the city, from what I hear and can see, since probably '87 or thereafter. So that's the only thing I want to point out, that difference in what you're saying. I understand what you're saying, but I think this is a different situation in that the city by de facto was maintaining it and is
I
kind
don't
of
know
taking
how long
over.
they've maintained it, to be honest with you. I haven't talked with anybody about that. I don't
Well,
know
no,
how
I'm
long
just going by what the residents up there say.
Public Works has
No, no,
maintained it.
well, I understand.
I don't know who paves it, who takes care of it.
So I have a question, actually, Steve. You did, this must have been an exhaustive survey, because I'm looking at all the notes. One of the notes actually references plan of Walker Street and Cottonwood Ave dated January 1947, on file at Laconia Department of Public Works. So where did Cottonwood Ave end in 1947? Do you know that?
Yeah, it ended right here, I believe. We have that on the plan.
Where the gate is?
No, there's a line down here, the Cottonwood, have you got the plan
Where
here?
the sign is.
I have your plan.
Yeah, where the
Right
sign
here,
is.
where the sign is
Okay.
saying we don't.
It's the line that comes down across this.
That's where it currently legally ends by what was apparently conveyed to the city or given as an easement. I don't even know if it's fee title.
Okay. Gotcha. So, but you're hearing that, claims that the applicant was supposed to convey the cul-de-sac. What's the response to that?
I didn't see anything where it said the applicant was supposed to. I saw in a couple statements that Howard said that they would convey it to the city, yes.
Why aren't the representations of an applicant to this board binding on that applicant?
Well, typically, when I tell this board that we will do something, it's part of the approval and it's put in as a condition. That's how it's done.
And you're saying since it wasn't an express condition of the approval in
Well,
1987?
not only
it didn't
was it
create an
not in
obligation?
there, they've had 20 years to ask the Taylor home to deed it over if they were supposed to deed it over. It isn't like it happened yesterday. It was in 1987. You are saying that this condition was placed on the Taylor home. The city never took any action to accept it or to take it, or never even spoke to the Taylor home up until the time when your public works director came in and said, we can't maintain this road any longer because we don't have an easement. I think that's what brought this all to light.
Okay. All right, I appreciate that. Thank you. Would anybody else like to comment on this matter?
Yes, my name is Margaret Probish, and I apologize, I'm losing my voice. Too good of a Thanksgiving celebration, I think. But thank you for giving me the time to comment. I did want to point out that in the minutes approving the cul-de-sac in 1987, the abutters pointed out that there was a statement by somebody from Taylor that the cul-de-sac would be deeded over to the city. There was also a statement in those minutes by the city that the cul-de-sac, specifically the cul-de-sac, would be maintained by Taylor. So I would submit that there was an isolated statement at the very beginning of the process by Taylor about deeding it over. There was a lot more discussions after that, including that Taylor would be the party to maintain specifically the cul-de-sac. So I do think we all, as attorneys, like to advocate for the best positions for our clients. But factually, it's not as straightforward as perhaps some people believe it is by solely looking at the statement by the Taylor home. So I would like the planning board to be aware of that also. I do agree with both of the parties that spoke, both being attorneys, that the law in New Hampshire is that laws can be made public roads by dedication and acceptance. As attorneys and advocates, we try to make our best positions as to whether or not that has occurred. My position and Taylor's position in this case is strongly that neither dedication nor acceptance has occurred. And I can make our arguments very simple and very straightforward because they are. When dedication occurs, it's very clear under New Hampshire law that there has to be an intent to dedicate, an intent on behalf of the owner of the property to dedicate. Here, as I already discussed, in the minutes themselves, there is no clear intent that this is going to be a public cul-de-sac. As a matter of fact, there's evidence to the contrary. Also, I do agree with the attorneys that have spoke that dedication can also be shown by conveying property with reference to a recorded plan. But I'd like to remind the board that here we're not talking about a recorded plan. The plan was never recorded. It is not the law in New Hampshire that dedication can be made by reference to any plan, even plans that haven't been recorded. I'd also like to point out in the deeds, the initial deeds out that conveyed the properties, they also had extensive meets and bounds descriptions to them. And in those meets and bounds descriptions, they did mention the cul-de-sac as one of the courses. That's it. That would happen in any kind of meets and bounds conveyance. And lastly, as Steve Smith mentioned, the reference to the plan that was in the deeds appears to be incorrect because it says it's a 1986 plan, when Taylor didn't even own the properties till after that and did not submit its application till after that.
Wouldn't sometime a plan be prepared before the actual conveyance?
You know, it's possible, but I mean, in this case, it's hard
That might
to.
have happened, though.
It could have. Yeah, it's unclear.
So I have a question for you. You said that in those minutes in which the others are claiming created the obligation to convey, that the city insisted that Taylor Home maintain it, correct?
Correct.
Have they?
On the issue of maintaining, my understanding is the only thing the city has done is plowed. In terms of like paving the area or anything like that,
That wasn't my question. Has Taylor Home maintained the cul-de-sac?
my understanding is they have not snow plowed.
Okay. Have they performed any other maintenance on it?
And that I do not know.
Okay.
I would have to find out.
Because I believe that Mayor Leahy was saying that the first time in 60 years he saw them plow it was just recently. Would that be accurate?
I do not know for sure because I haven't asked my client the question, but my general understanding is that the city has been plowing that area.
All right. Thank you, Attorney Purblish. Are there any questions?
I have one.
Charlie, of course.
Of course.
Columbo here.
Okay.
Just one question.
I'm just following up on you.
That's all
on what
right,
you
dude.
said. I'm just curious too on this maintenance stuff here. So they built the cul-de-sac, there's no question about that. I'm just wondering if any repairs have been done to it. Maybe there was a pothole or something like that.
I have asked that question, and my understanding is that the city has not done any repairs.
No, I'm asking if Taylor has.
And Michael Flaherty from Taylor is here. I do not know if he has personal knowledge, but I can defer to him.
Because what I would ask, just to say, well, you know, here's the records of the work we did, other than when we first built it. I'm just curious, that's all, so thank you.
Okay.
Any other questions?
Columbo.
Okay. Thank you very much.
Okay, thank you.
You've all done a wonderful job explaining a fairly complex set of issues here. Anyone else would like to come up?
Would you allow me 10 seconds?
Sure, no, you can have this, this should be your mic.
And I don't want to be what Phil McLaughlin used to use the word didactic, and I asked him what that meant, and he said preachy, and I don't want to do that. But the point that keeps being made is, you know, the sign going up and the city not wanting to plow because it wasn't ironed out. That should not, I say respectfully, be your concern. If there is a lawful order of this board, and the city is not enforcing it, or thrown in the towel, or whatever, that shouldn't change a bit what you do. I think your job is to defend the ordinance and regulations as
And
the
you would
planning
say that
board.
we lack the power to modify the approval. Okay.
Okay, thank you.
Thank you, Mayor. Anyone else? Come on up. Everybody gets one more bite at the old apple.
This is a real small nibble. I spoke to my client who lives there, and she was there all day yesterday, and the city came up and plowed, and then later on, the Taylor Home truck came up and went around the circle after the city had plowed it.
Probably just making sure they did a good job. All right, anyone else?
Did they plow or just turn around?
The representation was they saw a truck turn around. Anyone else? All right, I'm gonna close the public hearing yet again at 7:53.24. And we would ask the staff to, I guess my first question is, have we checked with the city solicitor's office on this?
That's a very good lead-in to my first comment.
I bet.
I would have appreciated the legal arguments being presented to staff prior to this meeting so that we could have gone to our legal counsel and better advise you. That not being the case, I'm at a disadvantage here. I will say, though, that you have heard a lot of argument, you have heard a lot of opinions, you have heard legal opinions, which really don't amount to anything for this board to consider. But I do want to talk about a couple of things that the board has asked questions about. And the abutters have made arguments about. So it is true that in certain circumstances, property owners own to the center line of the road. I will give you an example. Union Avenue, I can tell you for certain that at least the portion from, say, Main Street to Lakeport has never been accepted by the city council. And the property owners along that stretch of Union Avenue, and probably further along Union Avenue, do own to the center line of that street. And they have certain rights on the right-of-way, and they have certain rights on the side of the street that's within the right-of-way when it comes to like trees,
Because the right-of-way often includes land that's not officially
not
part of the
paved
street.
or not sidewalk or whatever.
Because it's
Right.
measured from the,
Right.
measured from the center line.
However, so that's a true statement.
Okay.
And for older roads, that is a true statement. I can't tell you if that would be a true statement for the original part of Cottonwood or not, because I'm not sure of the time frame that that subdivision was originally done.
Looks like 47,
Yeah.
roughly.
Probably was not accepted by the city.
Okay.
Probably, but I'm not certain of that. But let's use another example, and that's Linney Lane, which was developed 6 or 7 years ago. Some of you were perhaps on the board at that time.
Penny Lane?
Linney Lane.
Penny Lane, yes,
Off
I
of
know
Elm
where it is,
Street.
up on, off Elm.
That has been accepted by the city.
Mm-hmm.
I can tell you that the property owners along that street do not own to the center line of Linney Lane.
Okay.
Okay? Now, some of the other arguments about dedication and everything else, that is for a court to decide, that is for other people to decide. And I could probably advise you a little bit better if, again, if I'd had the arguments presented to me ahead of time, just as a courtesy.
Did you ever forward Mr. Leahy's letter of October 30th to council?
I did not, no. I was out of the office for a couple of weeks during that time period, so I did not. I do want to talk about, a little bit about the city maintenance. I've had several discussions with the Public Works Director concerning this cul-de-sac. And Mr. St. Clair is correct in stating that there are a number of other streets in the city that the Public Works Department and the City Council together have been and are taking action to do a multiple of things. And one of the things they're doing is ceasing maintenance on certain roads. And I'm sure that you're all aware of that. I'm sure that you've all seen it. It's been in the paper. It's been going on now for a year and a half to 2 years. Other streets they have decided to declare as emergency lanes. And part of that is because we have city infrastructure on those streets, like water pump stations or sewer pump stations. And in other cases, quite frankly, it's because of public outcry. City Council does respond to political pressure, for lack of a better term. And other streets are still being determined. But the issue here is not this draconian effort to cut off homeowners. The issue is, and I know people laugh when this gets said, but this is the reality of the world that we live in today. And the issue is, there's a state law that says the city has not accepted a street. We cannot expend money maintaining that street. And the second part of that is our insurance company says if you are maintaining a street that is not accepted and you do some damage, run into a car, knock down a mailbox, whatever, we're not paying for that damage because you shouldn't be there in the first place. And that's the part that the Public Works Department and the City Council is really responding to, because we don't want the city to be liable for
That's why they put up the sign.
That's why they put up the sign.
Beyond
Right.
this,
Now-
pass at your own risk.
For this particular street, there is an agreement between the city and Taylor Home. And I don't know if it's in writing, and I don't know if it's verbal, and I don't know how long the agreement has been in place, but there is currently an agreement in place that is allowing the city to go on, quote, the cul-de-sac, to,
Plow it.
the real purpose is they turn around. It's a convenient turnaround.
All right, but they're gonna do it with the blade down.
Right, they're not gonna
Then they're
bother,
gonna have to
they're not
clean
gonna
the
bother,
driveways.
right, they're not gonna bother to raise the plows while
Right.
they go around the cul-de-sac. The trash truck's gonna do the same thing.
Okay.
And yes, I agree that the FedEx trucks and the UPS trucks and everybody else is doing the same thing. However, there are several places in the city where we have hammerheads, Ts, Ys, whatever you want to call them, at the end of streets. And the exact same thing happens.
Okay,
That's
but,
going to happen here. You know, the FedEx trucks and the UPS trucks are going to do the three-point turn, and that's the way it is
I'm
in
not
a
asking you
lot
for
of
legal
places.
opinion, but the sign was put up.
The sign was
say,
put up.
beyond this, the city does not exercise ownership and control, right?
The city's not liable. That's essentially what, that sign doesn't say that, but that's essentially what the
What
sign means.
exactly does the sign say?
Says, I don't know exactly what it says.
No city maintenance beyond this point?
Right.
Okay. But doesn't
That
the
is-
putting
that
up
is-
of the sign contradict the statement that that the cul-de-sac was supposed to be conveyed? Or that because it was in the minutes, it created the obligation to convey?
Neither. The sign was put up in response to the awareness of the state law and and in response to a statement from our insurance company.
Okay.
That's why the sign went up. The sign went up, and we're not doing legal maintenance on that section of road is 100% unrelated to the legal status of that land at this
Okay,
point in time.
Okay. So what do you think we should do, Mr.
All right,
Director?
Can I ask a question before we,
Of course.
of course, thank you. I just, you said there were several other places around the city that have this Y or hammerhead, whatever you want to call it. But you have to, you would have to say, though, in deference to the residents on that street, that what they have now is certainly a lot more convenient or easier for people to go around the circle than to have all this backing up, or any backing up for that matter, right? I mean,
Convenience, I'm not going to deny the convenience,
okay,
but but from a legal standpoint,
I understand that.
I mean, this board approved a T cul-de-sac, for lack of a better word, just a few months ago at the end of Clark Avenue.
Because that's what they asked for,
Because
right?
that's what the plan called for. That was also designed by the city, approved by Department of Public Works, approved by the fire department, et cetera, et cetera, et cetera.
Because somebody asked for it.
And you approved it as
Right.
well.
Then what did this board approve in 1987? A cul-de-sac, right?
This board approved a two-lot subdivision with,
Showed a cul-de-sac.
that showed a cul-de-sac with, depending upon your interpretation, and we get back to opinions again, and,
Okay.
you know, everybody's got an opinion, among other things. And, you know, we don't,
What I'm asking the planning director's opinion as to what the 1987 approval,
I think there was an
Required.
intent, I think there was an intent at the time for the city to take deed of that land and for the Taylor home to convey it.
so that the
But it
cul-de-sac
didn't.
would remain in the public domain.
But it did not happen. It did not happen.
Okay.
And I can tell you that there are other locations in the city where that was also the intent, that was also the plan, and it didn't happen.
Okay.
But the city treated it like it did happen.
Some cases, yes, some cases,
In
no.
this case, I haven't heard anybody disagree that the city's been,
I think that over the years, from 88 or whatever, yes, that
Oh,
whether the plowing was done as a convenience, whether the plowing was done on purpose, whether the plowing was done
but it was done.
because someone in DPW or a a series of someone's in DPW thought that it was a city street and we should be plowing it, I can't answer that question, and we don't have the records one way or the other.
Okay, but my point is it was done and that the residents of that street have come to accept it as being done by the city and using it as a public way. That's all I wanted to point out. I'm not, you know, what you're saying makes perfect sense. I'm just saying the reality is how it's been treated since 1987 or 88, even, from what we're told.
The way people have used it may or may not constitute some legal
Okay.
situation. It may or may not, and I don't know the answer to that, and I don't think anybody in this board knows the answer to that. And I think to say, just because they've been using it that way, and it's convenient to use it that way, that they have a continual legal right to use it. That's not for us to decide. And the other point that I want to make, that with one of the assertions that's been made, is that in 1987, the board made its decision, and therefore, that's it. And I think you alluded to it, Mr. Chairman, but I want to be clear.
Right.
This board and previous planning boards have amended, modified, revised, whatever term you want to use, countless subdivisions, countless site plans over the years. To say that this one particular site plan cannot be amended or modified, I really disagree with that statement. Because
What is
we
the,
have a provision in our rules and regulations to amend site plans. That's what they're doing.
what about enforcement? I mean, there was a plan in 1987, that plan was conditionally approved by this board. At that point, isn't it this board and planning administration's job to see that it's enforced, and see that it's complied with? Does that enforcement power continue to this day?
I don't know.
Or was there ever an as-built that was put in that somehow changed the previous?
There could have been, but we don't know, because as has been stated, we had the sheriff's department come in and raid our records, and some of them got returned and most of them didn't, and we have big holes in our records.
Okay. So,
But
Are you
it is,
saying
but
that
it is,
need
but it
legal
is
advice?
true, it is completely true that the plan for that cul-de-sac in terms of, has never been recorded. I think both sides agree to
think
that.
we all agree on
So therefore, if it's never been recorded, it leaves, in my mind anyway, doubt as to what the Taylor property now intends to do, or somewhere along the line, they changed their mind, and I go back to the amendments. I think they're entitled to change their mind, and the fact that the situations exist for 30 years and not one other person has ever said to anybody that we can find a record of, hey, how come you haven't accepted this?
okay. Well, here's my thought. I think you should not take any action on it tonight because we do not have an opinion from the attorney for the city. Well, there have been legal arguments made by 3 attorneys on the record tonight. We were given documents tonight that were just filed today. There were representations made on the record in reference to the extensive packet here that this chair has not reviewed, nor have any of these documents, to my knowledge, been reviewed by city council. Not the city council, the legal counsel for the city. What are they called? It's not solicitor anymore, is it?
Legal counsel.
Legal counsel. And I'm disappointed that we don't have that information tonight. The applicant continued this, I thought, at least in part, for that purpose. And now it may have to be continued again. I don't know why this wasn't referred to council.
Mr. Chair, if I may.
Sure.
So, continuing is one option, but continuing, I believe the board should be making some form of recommendation to the parties involved and I'm not 100% sure what that recommendation should be, but
And I have
bas-
no idea.
basically, in shorthand, come to an agreement. Or your other option is to, and this, at some point in time, you have to make a decision on this
We
case.
certainly do.
Okay.
The applicant is entitled to this board
And
making a
what
decision.
will likely happen when you make a decision is that we go to court.
That's right. They go to court.
Somebody's gonna go to court.
Right.
If you deny Taylor, they take us to court. If you deny, the abutters, then they take us to court.
Okay, but I don't want us to just roll the dice either. We need a legal opinion as to what position the city takes regarding it.
I'm not 100% sure that
They're gonna,
that legal counsel will give you an illegal opinion on this matter. I can take these documents and I can talk to them about it and we can confer and I can give you a better advice, but,
Well, if it's gonna result in litigation, we should probably take no action until we have that advice. Right?
that's one option, yes.
Would we meet in non-public session to get that information? Would it be privileged?
You, possibly.
We could have done that tonight, though, couldn't we?
We
If
could
we
have
had
done it at any
attorney
point, we
here.
could have done it at any point in time between the last meeting and this meeting, yes.
What's the pleasure of the board?
Mr. Chair,
Yes.
if I may, I agree with you, Dean, that this may well end up in court, no matter what we do.
Right.
But, you know, I go back to the first thing I asked about, which was the gate. The removal of the gate and moving the gate down, because this was gonna have better access, make it the Taylor community, you know, the gate, moving that gate down. But I don't see the Taylor community has segregated the public from going up in their property. It's one entrance, but it's a big entrance, and you can go off into any street you want. The fact that you gotta turn around and come out that same entrance, to me, doesn't negate anything, doesn't stop the potential of, anybody can go up there, quite frankly, and guest of the many residents there, delivery trucks, whatever, it's wide open. So, for the Taylor community could very easily remove the gate from where it is now and put signs up like they have at the other entrance that say whatever they say, and not have to remove the cul-de-sac unless it's for other reasons that they want to move it, other than the gate.
But Charlie, they want it to be a gated community.
Well,
They
it's,
want the gate.
well, they don't have it at the other section. It's a big entrance,
But
so.
how does taking the gate down
Gate-
solve the problem?
Gate,
Well, I was told that the gate, they wanted to move, and Steve can correct me on this, but I thought you wanted to move the gate down so that house that's there would be part of the gated community, as such as
so,
it
but the
it
gate is not really the issue here.
Yeah,
The gate is not the issue here.
well, one of the
They're
reasons, but-
moving the gate, the proposal is to move the gate to where,
The sign is now, correct?
no.
No.
Okay, a little further back.
On the right hand, on the left-hand leg of the Y.
Yeah, it cuts the Y off.
Just, just before the driveway for the lot on the left.
Right.
But that would,
Which realigns basically.
that would include, though, making that not a
Gate.
circular,
Correct.
right, so that's the
But
difference. on that,
the proposal is to move the gate
Right
to
here,
where
because of this lot.
they are allowing a right-of-way and public passage. And the two easements that we have clearly state in my mind, and if you want to make it more verbose, then that's fine too, but in my mind, the two easements that have been proposed clearly give the right to the public to use that T and turn around.
Or
There's
the-
no
or,
extinguishing of public rights or use.
There isn't now with the cul-de-sac either, right?
Right, but
Well, I'm just saying, there isn't now, there's no restrictions for the public to use the cul-de-sac now.
Right,
the,
there's a sign. but
Other than the
It
sign that
just
was
said,
just
no,
put
but
up
all the
there.
sign says, we don't maintain beyond this point. Doesn't say, pass at your own risk or private road or any of
you
that.
could make the argument and again, we're into this
I understand.
arguments and opinion. You could make the argument that what is now the cul-de-sac and what is now Cottonwood Avenue in front of those two lots is private property. And at this point in time, I don't have any easements that allow the city to go on it or the public to go on it. There is language in the deeds, which I'm not gonna sort that out. That's not my job. It's not the board's job. We have agreement with Taylor Home and the city on a temporary basis to do what we're doing. And what the city is doing right now in terms of plowing that short section of Cottonwood that's in front of Mrs. Edelson's house to at least a good portion of the cul-de-sac is really a very generous accommodation so that she's not all of a sudden left in the cold while we try to work all this out. And the same thing with the trash trucks. You know, we're not cutting off trash service. We're not cutting off the city plowing that section of Cottonwood at this point in time because we're trying to work this out. If we wanted to be draconian, we could just, you know, where that sign is, cut it off and, you know, the plow would go up, drop the snow, and good luck to everybody
And
beyond
then the
that.
city council would have to react to the residents one way or
Absolutely,
the other,
right.
so.
So, I mean, you know, this is not being done in a vacuum, and it's not being done to punish anyone or to try to take anybody's rights away. You know, there are other private issues and interests at play here that some of them I'm aware of, and apparently I'm not aware of all of them, but some of them I'm aware of that have not come out tonight, and I'm not gonna get into them because they're not germane to the issue. But, you know, you can make a decision, we could go to court, and I'm not in favor of going to court. I don't want you to misunderstand that.
No, but I think you're right, it's gonna happen no matter what. But, Mr. Chair, I will just say for your benefit that I'm ready to vote tonight, but that's just me. So, thank you.
Okay, so you think we have
I'm
enough
ready.
information to make a vote?
I do, maybe not everybody else does, but I do.
Make a motion, Charlie.
Go ahead, we can have discussion after there's a motion and second.
Well, I have to have all the,
We're referencing PL 2019-0127 SP. And the chair recognizes Representative St. Clair to,
Charlie St. Clair, thank you very much. Member Charlie St. Clair, I'm not here as a representative for the state.
it's your title.
Be proud of it.
I would like to make, this is, again,
Charlie.
for discussion, make the motion that so read this part right here, for application for PL 2019-0127 SP, that, so my recommendation is that I approve it or disapprove it?
What?
Well, I'm not sure, you just.
Your
vote on
motion,
it.
dude.
Well, I would make the motion that we turn this down,
I'll second it.
So, a motion to deny the
to
application?
deny the application, correct.
Okay, and there's a second, there's a motion to deny by Charlie,
Oh, stop it, whatever.
and there's a second by Mike.
Yeah.
Any discussion?
Yeah.
Okay, Michael.
It seems like Taylor Home just wants to gain an advantage of getting a quarter acre of land back that they've given away for 32 years. And I can't.
That
understand-
is one interpretation.
Well, am I wrong, Steve? Taylor Home just wants to gain a quarter acre of land by eliminating the cul-de-sac.
Yeah, they believe it's an unnecessary use of the property.
Okay,
And you have to consider the homeowners on Cottonwood. Been using it for 32 years. Why all of a sudden, for financial gain of this, I hate to say conglomerate, but it's for a quarter acre of land,
I get you. I hear what you're saying.
I just,
So why wouldn't continuance of it be appropriate? So that
Well-
we can
Ready to vote?
get legal advice regarding the arguments, because I
Tony
think,
Smith
to
has
me,
been here
a
too.
key part of this is, did the Taylor home and does the Taylor home have an obligation to convey the cul-de-sac? I mean, if they did, then is that obligation current?
But that's not what we're voting on tonight, are we?
Well, they're certainly not gonna convey us a cul-de-sac if they're discontinuing it, Charlie.
You're asking us to,
What the abutters are saying is they like it the way it is. And, you know, we have to decide whether to allow Taylor Home to maximize their use of the property to the disadvantage of the abutters or not. And you've heard the chair say many times that the property owners that come before us have a right to the highest and best use of their property, such as it's allowed by law, within the law. And I'm not sure what that law is.
well, I would say, Mr. Chair, that the property owners that live on Cottonwood also have a right to the best use of their property.
Indeed.
And
And they want the cul-de-sac.
that has been there and was put there for the development of that area up there. I wasn't here at those meetings, but obviously, looking at the minutes or the records here, Howard Chandler, representing Taylor Home, thought this was a good thing to do. He didn't own the place, so he must have been going at the direction of his employers to make that representation. And I understand things change, but you know, you're not, making a change like this is not just saying, okay, I'm gonna develop this piece of property. You're gonna be affecting all the property owners on Cottonwood.
Right.
And I don't think that's fair. I just don't think it's right, any more than I think it's right anywhere else in the city where the city is full, this law that Dean has pointed out to us, a state law. I think the city should be fixing all those streets, whatever way they should. And yes, this should have been done back in 1987 or 88, but we know how it works here and how it has worked. Things get pushed aside and forgotten about and not followed up. Maybe the sheriff's department screwed that up, I don't know. But the reality is that in my mind and in the mind of the residents I've heard from on Cottonwood, that has been treated by the city as city property. They've been maintaining it. Certainly every time I've used it, which is quite a lot, because I have friends up there, and I normally just go up and make the circle to find my way out, has been that it's maintained by the city and to be used by the public, not just visitors to the Taylor home. So with that in mind, that's why I made the motion. And no matter what we hear from legal, we're still gonna have to vote on this. And no matter how we vote on it, somebody may in fact wanna take it to court if they feel it's important enough. So putting it off for another month or something I don't feel is
Okay,
gonna
but-
change anything.
All right.
I
So,
can't speak for everybody else, though.
all right. Is there anyone else that would like to speak on the motion? Brett?
So I don't see how we can deny or approve it. In my opinion, it needs to be continued because it's really almost a land ownership issue here on who has a right. If I owned a piece of property at the end of the road, and I don't care if I let everyone on that road turn around in my driveway for 30 years, if all of a sudden somebody came out and said, hey, look, if somebody slips in your driveway while they're turning around and falls and hurts themselves, they can sue you because it's actually your property. And I would say, okay, I don't want to allow them to turn around there anymore. Then that should be my right because that's my property, whether I let them turn around on it or not. The question here is, who really has control over that thing? Because if the city 100 feet down the road has placed a sign saying we're not responsible after here, that means once you cross that property line onto my property for that quarter turn of the cul-de-sac, anything that happens on that is Taylor Home's responsibility.
Little late.
So it's kind of up in the air, like whose responsibility is that? Legally, if that can be considered, then we can vote on this, because if Taylor Home has control of that, why can't they put up a fence and keep people from going around? If
Why
they
didn't
don't
they put
have
up
the control and that should have been conveyed to the city a long time ago, well, then it needs to be conveyed to the city Taylor Home can move their gate right to the edge of what's being conveyed to the city, but then the city has to take control of that. Something has to be done where someone has control of that. And once they do, we can either approve or disapprove.
There is control of it right now, I would say, though, because the city has had control of that, or the public has had control of that since 1988. And Taylor could have put a stop to this a long time ago. If they felt that their property rights were being hurt, they could have put a fence up back in 1990.
Well, the city could have put that sign up, but something must have preempted the city to say, hey, red flag.
We know what that
We need to
is.
put a sign up.
Yeah, we know that.
And once the city did that, maybe that raised a red flag for Taylor that said, whoa, if the city's not accepting responsibility, we shouldn't either.
I
Well,
don't
we're
know.
guessing.
I
We
don't
don't know.
Yeah, it's all
We don't-
speculation.
We don't know when they were
But
thinking about
so-
doing this.
So my point is, we can't make a decision one way or another until we figure out whose beast this is.
Well,
Okay.
with all due respect, I would say the city made that decision. Actually, Taylor Home did too, by not putting a fence up there in 1990. 1995, they could have said, hey, man, we never gave this to the city. What are we doing here? Boom, the fence goes up. And this is just an example, but anybody knows this, and I know it simplifies it by adverse possession, but if your neighbor starts using 20 feet of your property, and you never stop that neighbor from doing it, whether it's parking a car or something like that, 30 years down the road, your neighbor could say, hey, man, you can't throw me off this property. I've been using it for 30 years. You never, ever raised a stink about it.
This is not, but that's not germane to this issue tonight.
Well, I don't know that it is or isn't, but I'm just saying, it proves the point that if Taylor Home was concerned about this being their property, they could have put a fence up 10 years ago, 5 years ago, and they never did, for whatever reason.
Because the city didn't have a sign.
Well,
Okay.
that's my point. They were using it, the public's been using it for all that time.
Does anybody else want to weigh in on this motion? All right, so the motion is to deny the application. It's been moved and seconded. Are we ready to vote on it? All those in favor of denying, granting the motion, signify by raising their hand. Opposed?
Wait, she was
That
putting
was
her
it.
hand up.
Yeah, so 2 in opposition so far and 2 in favor of.
No,
No, I was in favor.
You're in favor. So 1, 2, 3 in favor of Charlie's motion? And you're opposed? Well, then the motion carries. It's been denied. I'm going to abstain. And I'm going to say on the record, the reason for my abstention is that I'm upset with the staff because I requested by email prior to the November 6th meeting that the October 30th letter be forwarded to council so that we would have the advice of legal counsel. We are now past that. We are now at a second meeting when we were continued from that date. And we still don't have legal opinion. And we've heard from 3 lawyers tonight. They're all made complicated legal arguments. So, but the motion carries and the application has been denied. And that's it. Okay, next. PL 2019-0128 SU, 11 Sonia Drive / 157 Massachusetts Avenue. It's a boundary line adjustment. This was continued from November 6th, and we'll hear from the applicant. Sarah, I'm sorry, you put your hand up kind of late, so
Oh,
I
I
didn't know if
know,
you were voting
because
with
I'm
Brett
so,
or
like-
voting with them.
Neither did I.
Which would have meant that I couldn't abstain because I would have had to cast the deciding vote.
Couldn't just-
Thank God.
Yeah. Hi.
Good evening.
Hi. Could you state your name for the record?
For the record, Dave Dolan, David M. Dolan Associates, for the applicants, Mark Ashley and Ann Jalbert, owners of property at 11 Sonia Drive.
Mm-hmm.
And I believe they've been patiently waiting in the back tonight. And also Patrick and Mary Coburn, who own property at 157 Mass Ave. The Ashley and Colbert, yes, Ashley and Jalbert properties on the plan on the left. It's the property that's outlined in yellow, and that's on Sonia Drive, which is at the end of Mass Ave. Sonia Drive's a private road. It serves the residents on that tax map, Lot 21. And the Colburn properties outlined in blue.
Yep.
There's 150 feet of frontage on Mass Ave. They're both developed residential properties. Lots of record, and the application is to convey about an area of about 18,000 square feet, which is a block bounded on the south by undeveloped Jefferson Street and on the left by what's undeveloped Paradise Drive. They're basically exchanging the backyard from Lot 21, which is Ashland Jalbert, to Colburn, which is Lot 23. So the Colburn property will increase in size from about 16,000 square feet up to 34,000 plus square feet. And Ashland Jalbert's property will be reduced in size from 41,000 square feet to about 23,000 square feet. And just for the record, at the last meeting, we discussed a waiver request, which has since been withdrawn based on the input from the planning staff. Monuments have been set. No change in road frontage on either lot, so I'd be happy to answer any questions the board might have.
Did you say that Paradise was a paper street?
Yes, it is.
What is on it now? Is there a path or a track or something?
It's
Okay, it's just not developed.
just dirt.
Okay. And Jefferson as well,
That's correct.
is it used as a drive or access to any lakefront properties?
No,
for
it is
example?
not.
No? So the access is Sonia Drive?
Access is Sonia Drive. In the past, Sonia Drive actually extended across the railroad on the east side of the property to property that's now accessed by Appleton Street.
Oh, okay,
So that was discontinued a number of years ago.
okay. All right. Any questions of the applicant? Okay. Public hearing? At 8:31, call the public hearing to order. Are there any abutters here regarding this boundary line adjustment? Any abutters? Any members of the public that would like to be heard on this application? All right, sensing none, we'll close the public hearing at 8:32, and we'll hear from the staff.
I know originally you had a request for a waiver of sidewalks. We have since, staff has since further investigated, and the requirement for sidewalks is in the subdivision regulations, and this is not a subdivision.
BO.
This is strictly a
BOA,
boundary
yeah.
line adjustment. Nothing changes on the streets or the uses of these lots because of this boundary line adjustment. All we're doing is moving the
Lucky for you.
line.
No waiver required.
So we advise the applicant to withdraw that waiver request, and you have a letter from them doing that. And then our staff recommendations are listed out for you. This is a pretty straightforward application.
Indeed it
The
is.
only thing that we would like added to the plan is a note that Paradise Drive and the adjacent part of Jefferson Street are not developed or accepted, and therefore they can't be used for frontage or any further development without taking some very significant action, which
What would the note say exactly? Let me see that. If I can find
Paradise
that.
Drive and the adjacent part of Jefferson Street are not developed or accepted streets and cannot be used for frontage unless they are developed.
Gotcha. All right.
And not to beleaguer the point, but this would be a case where the adjacent property owners could, and I emphasize the word could, claim right to the center lines of the street, but they would have to take action to do that.
Correct. All right, any questions for the staff on this one? Sensing none, what is the pleasure of the board? Someone care to make a motion? Brett?
Sure, I'll make a motion that we accept PL 2019
We have to accept first, do we?
We have to approve it.
So just approve. Acceptance and approval are two different things. So Just one.
So I'm good with approving.
Approve, yes.
Okay. As I was saying, I make a motion that we approve PL 2019-0128 SU 11 Sonia Drive for the proposed boundary line adjustment, accepting the staff recommendations with the addition of that note that Paradise Drive and the adjacent part of Jefferson Street are not developed or accepted streets and cannot be used for frontage unless they are developed.
Thanks. Is there a second?
I'll second.
All right, so now we have a motion by Mr. Bellevue and a second by Ms. Jenna. And a question for the applicant. Are the dates, the project completion deadlines acceptable to the applicant? We have plan revisions by February 4th, 2020, Mylar final plans by March 3rd, and completion by December 1, 2020?
We can meet those, yes.
Okay, so those are acceptable to the applicant. Any other discussion on the motion? All sensing none, all those in favor signify by raising their hands. Opposed? Carries unanimously. Thank you very much. Good luck. Okay. Next. PL 2019-0122 CUP. This is 40 Carriage Lane. It's a proposal to add a deck within the 50-foot wetland buffer. And this matter was accepted at the last meeting, and we'll hear from the applicants.
Good evening, Board. My name is Kenneth Brunel. I'm building a house at 40 Carriage Lane, and I'm proposing to add a deck to the back of my house. And hopefully get approved.
Okay. So why should we give you an exception to the 50-foot wetlands buffer?
When I bought the lot, it had a 30-foot setback. I was unaware that it had a 50-foot setback until I put my building permit in. The planning board contacted me, said their reasons, so I applied for an application. I sat in front of, I think it's environment for the pond.
Conservation?
Conservation, and they approved me last meeting, and,
So conservation does not oppose your,
no, they said they approved it and sent it to the planning board with their approval.
okay,
Planning Department.
Say again?
Planning Department.
Planning department.
yes. Okay, any questions for the applicant? Okay, no questions. We'll open a public hearing for you then. 8:37 PM on the nose. Are there any abutters here that would like to be heard? Any abutters? Any members of the public? Any members of the public? All right.
Mr. Chair, sorry, before he disappears, I just have a question. How long ago did you buy this property?
Over the summer.
Over the summer? Would you, I'm just curious, I guess maybe it's a personal thing. Do you think if you had been told that you couldn't do this, put this deck out there, would have been something that would have changed your mind about
It would
buying
have
the
changed my
place?
mind on the money that I paid for the lot,
Yeah.
definitely.
Okay,
But,
I'm just curious about
yeah,
that.
no, I raised that considering in the last meeting.
I wasn't
And
here, so.
I guess, like, I've asked, but how they can just change a rule when it was approved. But, I mean, the city can do that. It is what it is. I'm not gonna disapprove with it. They can do what they like.
No, I understand.
So-
I'm just curious what your thought was on
But
that.
I went back to the people I bought the land from and the real estate agent. They were unaware of it, never received a letter saying that that's changed. So I had full intent when I bought the lot. I put a house on, the city approves a box where you put the house in. I met all the rights to it. My deck fit, everything fit. So my house is 51 feet from the line. So my house is fine, but I can't put a rear deck on it because of this 50-foot rule.
Okay, gotcha.
So that's why I'm here.
In the deck, it's probably in here, and I didn't see it. The deck's just on,
Yeah, columns. And it's 2 feet off the ground.
well, that's low, okay.
Any other questions?
Is this in Southtown?
Yes.
And the condo association's okay with?
Yeah, Long Bay, yep. I had to go in front of them, prove everything, all my deck, like material, everything like
A
that.
lot of work, this house building stuff, isn't it?
Yeah.
You did fine tonight. All right, 8:38, we'll close the public hearing and hear from the staff.
Thank you.
Thank you.
So when these lots were originally created many years ago, we did have a 30-foot buffer from the wetland. And to be perfectly honest, The quote wetland, at the time the lot was created, was the drainage pond. What has happened over the years, 25, 30 years, is what happens to most drainage ponds, and that has become, that they become official wetlands, and that's, and they're not wetlands because they're wet, they're wetlands because of the plant vegetation that grows in them and the critters that make their home in there after the years go by, so.
Does that happen there, Dean, in that?
It has,
particular-
yes, it has.
Do they have to apply to the condo association, these animals and stuff?
They have a waiver,
Probably rules for that.
yep. So.
Color of the frogs.
So I don't remember exactly when we changed the buffer from 30 to 50 feet, but we did that a number of years ago, and it applies to every single existing lot in the city and every proposed, when the developers come in with new lots, every proposed lot, it applies to every single lot or proposed lot in the city. However, as you know, you have had multiple requests from people who have lots that were approved prior to the 50-foot buffer taking effect, to ask for the CUP to go back to the original 30 feet. That's the request here. I think if the request had been to go even closer to the wetland, that there would be a different result from conservation and everything else. But in this case, a little bit of hand-wringing, but for the most part, there's an acceptance that the 30-foot buffer is probably the right thing to apply in this case, so.
And conservation's on board?
Yes.
Because I would think with just poles in the ground, it's not, it's not really
It's
interfering with it.
coverage, it's taking away
It would prevent wildlife and the
absorption
aquatic
of.
plants and all that.
And it's not just the deck. I mean, one of the things that I discussed with the applicant when they came in was, they could have come in with to be 38 feet from the buffer to accommodate the deck, but once you step off the deck, you're now in the conservation zone. You can't mow it, you can't maintain it. So I said, you're gonna wanna have a backyard. They say they don't want a big backyard because they don't wanna mow it and maintain it, and I get all that, but they're gonna need some area, so I said, you go to the 30-foot, so you've got area around your deck that you can walk around and maintain, and
And the deck, when it rains, the water will drop down through the deck?
Straight down, it doesn't bleed into the pond or
Okay. So
All right.
the land is level, actually, it doesn't slope in.
Are there any other questions for staff?
and you have our recommendations, are pretty straightforward.
Yes, indeed. Thank you. Would anyone care to make a motion?
I'll make a motion to approve application PL 2019-0122 CUP for 40 Carriage Lane for adding a deck with respect to the recommendations from staff, Roman numeral 1 and 2.
All right, we have a motion by member Jenna, seconded by Mr. St. Clair. Let's see, I have a question here. There's a difference between the docket number that's on the agenda and the one that's actually on the staff review report, I think. It says PL 2019-0128 and this one's CUP. Is there a difference? This SU is site plan, isn't it? Subdivision.
Well, I'm not sure what you're looking at.
The application number that's on the staff review report. It says PL 2019-0128 SU.
Right.
Mine says 122.
Oh, you're on Sonia Drive, you're on the wrong page.
Oh,
Carry on.
I hate Apple products, I really do. Never mind. Somebody get me out of this and make a motion, please.
It's been motioned and seconded.
Okay? Oh, jeez. I got discussion?
Seems all right.
Sensing none. All those in favor signify by raising their hand. Opposed? Okay. Thank you very much. Sorry about the confusion.
Neighborhood.
Have
Sorry to
fun on the
wait so
deck.
long.
Is it big enough to fit the entire planning board?
I was just thinking that.
He's probably got some burgers,
Thank you so much. Have a nice
You're welcome. Have a good winter.
You mean the department and the board?
So what, yeah, okay. All right, back to the agenda. I swear the link is wrong. Okay, our next item, PL 2019-0124SU, 55 Bay Street, 6 Winnisquam Ave. This was accepted on November 6th, and I see here the applicant has requested a continuance to our January 7th meeting. And then the next one as well, the same thing, the Union Avenue.
Mr. Chairman, you need to take a vote to do that, please.
Okay, so one at a time. So, can we have a motion to continue this application at 55 Bay Street to January 7th? Please?
All right, I'll make the motion, we continue, P-120, what's that one in front of the 24? Oh, that's.
P is supposed to be PL, I think.
Okay. PL 2019-0124SU, 55 Bay Street, continue to January 7th.
All right, we have
Second.
a motion and a second. Is there any discussion? Sensing none, all those in favor raise their hands. Opposed? Motion carries unanimously. We're now on PL 2019-018, 0108 SP, and 0115 CUP, 903 Union Avenue. It was accepted on November 6th, and then the applicant is requesting a continuance to January 7th due to a family emergency.
I'll make a motion, since we're going down the line here, to PL 2019-0108 SP and 0115 CUP, 903 Union Ave, that we continue this at our January 7th meeting.
Motion by Mr. Billop. Is there a
I'll
second?
second.
Second by Ms. Jenna. Any discussion? All those in favor signify by raising their hand. Opposed? Motion carries unanimously. PL 2009-00110 SP and 05-0020 SU and 05-028 CUP. It's a cluster at 198 Endicott Street North in the Weirs Beach Village, I guess is the property name. Proposal to amend the 2009 notice of action items. The use of the areas above all garages is restricted to I would assume finished, not fished, space, and either not used or only used for storage. And this one, we have to vote on acceptance of the application first. Is the application in order and ready for acceptance?
Yes, it is.
May I have a motion to accept this application?
I'll make a motion to accept application 05020SP, PL 2009-0110 SP, 05028 CUP.
Second.
Motion and second. Any discussion? All those in favor signify by raising their hands, and it's done. It's been accepted. Now can we hear from the applicant regarding this application, please?
Good evening. My name's Tom Furtado with Impact Development Advisors Incorporated, and we are the owners of Weirs Beach Village at 198 Endicott Street, where we are developing the final handful of homes in that existing project. There are currently 73 homes of the 85 total approved that have been completed and transferred to individual owners. The request here is for minor adjustments to the 2009 approval, specifically, as you mentioned, Mr. Chairman, that item number 3 states that only the space over the garage may only be unfinished for storage. We're requesting that some of the space above the garage be finished as living space. One of the designs that we have has a 2-car garage with some living space above, and that would be useful. Item number 5 states that no home will have no more than 2 bathrooms. One of the things, and we're asking that be amended to allow more than 2 bathrooms. One of our designs we've added a powder room on the first floor, so we would like to add that powder room, which would be more than 2 bathrooms. One of the things I do want to note is on the agenda, it states that there's a typographical error that states that no more than 2 bedrooms are allowed, but it's actually the bathrooms
okay.
is the issue. And then lastly, item number 8, we would ask for a modification. That original approval from '09 states that all homes will have a 12-pitch roof, while some of the homes of the 73 that were constructed and sold already do have 12-pitch roofs. There are sections of the homes that do not. So we would simply make sure that we're in compliance with the approvals. that the 12-pitch requirement be eliminated.
Do you have any idea why those restrictions were in the original approval?
I cannot imagine why any of those restrictions would be in there.
Neither can I. Thank you. Are there any questions for the applicant?
You took my question, 'cause I'm curious myself about the bathroom one.
You know, if you can't put your mother-in-law in the garage, there's a problem there, I think. That's like throw mom off the train. Okay, any other questions, anything? All right, thank you very much. We're gonna open a public hearing on this one at 8:49, almost 8:50. Are there any abutters here that would like to be heard regarding this application? Any members of the general public? Any people just wandering through? No? All right, so we will close it at 8:50 PM, and we will hear from staff. Can you answer my question, why those restrictions were in there?
I cannot. We have researched the minutes and the conditions of approval, and it is not clear why those restrictions were in place, other than the cottage look, the 12-pitch.
Is that what that is, the 12
Yeah,
pitch?
kind of get that cottage look. That's the only one that, and
So
that's
that's like a
an
fairly
architectural
flattish-
style. No, that's very steep.
It's steep?
Yeah, a very steep pitch. Yeah, 12-12 as opposed to.
I don't know what pitch
But anyway.
is. Pitch is something I get on my
The only
hand.
thing that I will say that the original application came in 2005. 2005 was, if not the height, very close to the height of the building boom that occurred in the early part of the century.
Member of the board. I remember.
Before our infamous 2008 crash. There was concern expressed, not necessarily in the minutes, but in general throughout the community and elsewhere in the state, that if you build houses that have like 3 bedrooms and everything else, you're gonna have a bunch of kids, and we didn't wanna have a bunch of kids in the school department. And that was the general consensus of the day. I can assure you that
Population's declining.
the capacity of the schools in Laconia are very easily accommodate any number of new students that may generate. However, when
The
you,
enrollments have gone down.
enrollments are way down from 2005. However, I will also state that currently in this development, I don't know the exact number of school-aged children, but it's very, 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 very low. So therefore, it's not a concern for this, the school department. It's not a concern for the city from the standpoint of overloading any of our systems or services.
So the applicant is the developer.
The
Is there
current,
like an association and
there is an
owners?
association, and they have, they're.
Are they in
good.
favor of this?
Yeah, they have no problems with this.
All right. Brett, did you have, I saw did you have a question for staff?
No, just engineering things. With a 12-pitch roof, you wouldn't have the space above any garages, except for a very small thing anyway, so
Okay.
that kind of goes hand in hand with only unfinished storage spaces up there. But if you allow less than that, then you're opening it up to actual like dormers or whatever on
Gotcha.
the second floor.
Well, it doesn't say you couldn't have a dormer on a 12-pitch roof, though, does it? If you wanted to increase the floor space, you could add dormers, bay
Then
windows,
you'd have
anything.
a bunch of knee walls.
Well, that's true. I have several weird angles on the second floor of my house. Yes, Charlie.
I thought we were talking about bathrooms. I thought that was a misprint.
There's three requests to amend here. One of them is to exceed the limitation of 2 bathrooms,
Why would there be a limitation on bathrooms to
The
begin
kids.
with?
because it limits the,
The sewer system?
The number
Yes.
of people that can
it's
actually.
not,
The people thing again?
it's an attempt to limit the number of people in the home, I guess.
Jeez, I know
It makes
apartments
no
that have
sense to me.
15 people.
I had to
and
stand
they
in
got
line
one
my whole
bathroom.
childhood, so I
So
don't get
I'm
this
just
multiple
surprised.
Yeah,
bathrooms.
I mean, I lived in a ranch with 7 people with 1 bathroom, so,
Yeah.
Yeah.
get
Okay,
over
so
it.
that's
you know.
not a concern about the
It's all
plumbing.
maximum possible flow.
All right, so we can stop this talk
Okay.
now, because I
I
need a
just
potty
wanted to be
break.
sure on that, because I was
There's
confused.
no sewer capacity issues
Okay,
at
that's
all.
what I wanted to know. All right,
Alright.
thank you.
Okay. So, staff recommendation is,
To approve these 3
Approve it.
modifications, yes.
Any questions for our staff on this? All right, sensing none, what is the pleasure of the board? Who's up? Whose turn is it? Charlie?
I knew it. I make a motion that we accept application 05, approve, sorry, 05-020 SP PL 2009-0110, that might be an O too, SP 05028 CUP.
Is there a second?
I'll second.
All right, so there's a motion by Mr. St. Clair, and there is a second by Ms. Jenna. Is there any further discussion regarding this matter? Sensing none, I'll call it.
Wait a second, I think we just need to add in, because it's not in there, the number 8, eliminating the requirement for the 12 pitch.
Oh, yes,
Is that just in,
Oh, sorry.
right.
The conditions that are listed under the recommended structure types is what would be the new approved structure type listing. And
okay,
that-
so that overrides it
Yep,
just by
that's amending that.
accepting
Yep.
the staff recommendations. Okay, good.
Okay, all right. Any further discussion? Sensing none, all those in favor signify by raising the hand. Opposed? The matter carries unanimously. Thank you very much. Moving along. PL 2019-0134 SU, 50 Lighthouse Cliffs, Meredith Day. Is that Day or Bay? Meredith Bay Development. Proposal to adjust boundary lines between lots 115, 116, 117, 163. What? They're just typos. They're just typos. It's no big deal. We need a motion to accept this application. Is it in order?
It is.
All right, well, what do you think? Motion to accept? Anybody on this side?
I make a motion that we accept application PL 2019-0134 SU.
Is there a second?
I'll second.
Motion by Mr. St. Clair, a second by Ms. Jenna. Any further discussion? All those in favor signify by raising the hand. All right. Good evening, sir.
Good evening.
Enter and sign in, please.
Chris Dupree, agent, and on behalf of the applicants.
Thank you.
I think the plan and the application spells out pretty well. It's just some boundary line adjustments amongst 4 different properties. All the owners are obviously in agreement with these changes, resolving a couple of encroachment issues and a little horse trading back and forth.
Okay, I'm looking at your application documents. Okay. Is there anything else you think we need to know about this one?
I don't believe so.
Okay. Thank you very much. Any questions for the applicant regarding this boundary line adjustment? Nope. All right. We're going to open the public hearing for a bit at 8:57 and 40 seconds. Are there any abutters here that wish to be heard? Any members of the public? All right. At 8:57 and 51 seconds, we are closing the public hearing. We're getting down into the little digits now, Kalina. Staff? What do you think about this one?
This is a pretty straightforward boundary line adjustment. The lots are conforming now under the cluster development concept. They will be conforming afterwards. All you're doing is adding some square footage to some lots and taking away from others. And not to, again, to belabor the point, but again, we are modifying a subdivision approval.
Yeah, I saw that. I caught that. All right. Any questions for staff? Sensing none, would anyone care to make a motion?
I'll make a motion.
The chair recognizes Representative St. Clair.
I make a motion that we we approve application PL 2019-0134 SU.
Is there a second to this most excellent motion? The second is by Mr. Delvecchio. Any comments? Any further comment? All right, I'll call the vote, then all those in favor signify by raising their hand. Opposed? Another unanimous decision by the board. Thank you very much, sir. Good luck. I assume this kind of thing is done to make the lots more saleable.
What's that?
To make them more sellable, to improve the
Oh.
value.
More than likely.
Yeah. Probably not just sort of random or anything. All right. All right, moving right along, PL 2019-0142 SU and 0145 CUP, performance zoning. This is 111 Church Street, it's the proposal to convert office building into 12 residential units and construct a 4-unit residential building and garages. And there's a waiver requested for up to 80% of the impact fee for infill and reuse. I believe we had a preliminary demonstration of this, or a presentation at the last meeting. We need a motion to accept before we can go forward on this. Is it ready for acceptance?
It is.
All right.
I'll make a motion to accept application PL 2019-0145 CUP and PL 2019-0141 SU.
All right, so moved. Is there a second?
Second.
Second by Mr. St. Clair, motion by Ms. Jenna. Any discussion? All those in favor signify by raising their hand. And the application has been accepted. And the chair recognizes Mr. Smith again.
Chairman.
Mr. Smith.
I'm still here.
Yes, you are. You've been standing at that podium, is from my recollection, for about 20 years.
It's been a while.
Yeah, maybe more, right? I mean, I'm not as old as,
28 years.
I'm not as old as you, so
48 years to be exact,
yeah.
if you're counting.
Yeah, who is the first chair of the planning board that you, in Laconia, that you appeared before?
First chair,
Yeah, do you remember?
Peter Hance was the first planner,
Yeah?
and about 30 more after that.
Yeah, there was a bit of a turnover there.
We finally got some good ones.
Careful, you know, some
Strike
of,
that, please.
some of the former incumbents may watch YouTube once in a
Strike
while.
that, please.
Dude.
Mr. Chairman, planning board members, for the record, Steve Smith. Steve Smith and Associates, I'm here representing the applicant for 111 Church Street, tax map 425-4480, piece of property about 9.91 acres of land area, fronting on Church Street, kind of a dogleg shaped lot. My client was here with the board on a preliminary review concept plan because we're
Morissette.
coming under, we have a conditional use permit we're requesting for the performance standard zoning in this particular area. We have a site plan subdivision application because these are residential units which could be rented or sold. I'm thinking they're probably rented to start, but wants the option to be able to sell them if they decide to.
Sure.
And we have a waiver request for the reduction in the impact fees because of the infill. And as I understand it, I guess it only applies to the existing building that's on site. And this is the former site of the Lakes Region Mental Health Care Center, which has moved downtown now. The existing office building fronts right on Church Street. It's roughly 13,000 square feet with 66 parking spaces. If you look at your existing conditions plan in your package, which should be the first plan, you'll see that this lot is mostly occupied by building and parking, pretty much.
This, again, this thing doesn't display properly. When I get to the plans, I got blank. So, there it goes. Oh, and now it says a problem occurred.
I can't get it either.
Something wrong with it.
See, that's why I use paper.
Well, I would, yeah.
I
It's
have
okay.
paper here too for
It's up there.
my colleagues.
The one on the left, on my left.
I see it.
is
Steve, it's
existing
right, it's
conditions.
actually right, there's a screen right on the front of the
Oh,
podium.
wow, you guys have got it all.
Well, for us old guys.
Our proposal is to take the office building itself, the 13,000 square feet, and convert that to 12 residential units, and to build a 4-unit building to the rear of the property for a total of 16 units, and then to build 2 other buildings as garage units, so there'll be 16 garages, 1 garage for each residential unit. And then we have an additional, I think it's an additional 12, have it here somewhere.
Parking?
15 outside parking spaces, some handicap parking in front of the buildings on
Where's the snow gonna go?
both units, and additional parking for people that are visiting or people that want to park and take groceries in and then put their car in the garage, so to speak. This is going to involve taking out all of the existing pavement that's there now, redesigning both sewer and water. We're bringing new water connections for fire safety, new drainage lines, new sewer to the back of the building of the Unit 4 itself. Pretty much a rehab of the entire site. The reason why we came under the performance standards is that this happens to be one of those lots, if you go to, you look to the right, when you look at setbacks and average, we have the CVS, side setback 172 feet and 52 feet. How do you average that out? Pretty tough. Because that's a corner lot, the next lot is vacant, there's nothing to average anything out there. If you go back on Church Street back towards the Spar, you have another corner lot, doesn't have any rear setbacks. You have, so everything is convoluted.
Sure.
And by the time you try to apply standards to it, the only thing you're gonna have there is that building in the front.
Are you decreasing the impervious surface?
I think we're slightly, but not only are we decreasing the impervious, we are actually increasing the stormwater treatment.
Yes.
Which it has none today. Has some catch basins out there, but we've put in some systems to take care of stormwater drainage. And I think I don't have it right off the tip of my tongue, the existing green space is 30.2%, the proposed green space will be 32.8%. So it's not a large increase, because the whole lot was paved before. But again, we are providing an increase in green space. We are providing some stormwater drainage that it doesn't have, and upgrading of all the sewer and water.
These gonna be like market rent?
I guess Kevin would have to answer
Or
that
you
one.
gonna sell them, or market rent?
It'll be to the higher end of
Yeah,
I've given you some elevations that I got today.
yeah, they're attractive. That's nice. Yes, Charlie?
It may be in there, but Steve, how, around the city, we've had some things before the board before where I think staff has asked them, when they pave a driveway or something, they're using that pavement that
Porous
absorbs
pavement?
water. Yeah. Is that something that would be good here, or is that?
We use
maybe
it,
not working
we
so
use
well?
it when we absolutely have to.
Because,
Well, because we absolutely have to. Because we can't make green space, okay?
that more
It's a
expensive?
maintenance problem, it's a maintenance nightmare. We used it, for instance, up at the industrial park
okay,
for Tyflex.
Yep.
In the rear of their property, they needed tremendous amount of parking, they couldn't get green space, and of course you allow that to be counted as green space. The problem with that is that the porous pavement is where the parking spaces are. The drive lanes are not porous pavement because they can't handle those turning movements.
okay.
Accessing for all the big trucks, that can't be porous pavement, it won't stand up to it.
Plus, the vehicles are over the porous pavement, so wouldn't it divert the water away? What is it?
No, it's designed so it drains back to the porous
Oh,
pavement
okay.
itself. That's not really the issue. But the other issue is that, I don't know, you deal with people plowing my office, they're in there, they're plowing, they're sanding, and you can't sand this stuff. If you sand it, you're in trouble.
Right.
Okay, I didn't know, because I'd
it
never
would
heard a
clog it.
report back
It's,
from it,
it's, it's
so-
a real maintenance issue.
Okay.
It's about 60% more money,
And
and it becomes a real.
It doesn't work anyway, it doesn't sound.
Well,
like
no,
it.
I'm not saying it doesn't
does
work.
work,
It's,
okay.
we
Fine.
use it in appropriate areas.
But Charlie, this is an urban site, and it's
No, no,
all.
I'm just asking, because we're always looking to
All of
control
our lake,
runoff, so.
almost all of our lakefront shoreland protection plans we do today, we use porous pavement because it's just residential traffic. We use porous pavers. We try to use porous technology wherever we can.
Okay, no, I'm just curious. So the
If it-
stormwater treatment you're doing there is with More catch basins, or how, you
We,
mentioned
we
that,
have,
so.
we have some, we're taking care of all the roof water, which doesn't happen now, it just runs right into the parking lots themselves. And so we've got areas where we're taking care of all that storm water coming off, that more impervious stuff that we're building, those buildings.
Yeah, so you're gonna control the water coming off the roof, because it's gonna go into a
Eventually go
sewer, or?
into- it's gonna
Downspout into the
eventually-
drain.
Well, we try to infiltrate as much as we can, and what won't infiltrate it into our drainage collection system, but it gets some treatment before that
So
happens.
it's, the downspout's gonna go into like a gravel bed, and then
So-
any runoff from that will go into a catch basin.
Right, because we have overflow pipes to allow that to happen.
And there'd be probably some grass in between there, and it would clean the,
So bottom line, it's an improvement over what's been there.
I believe so, yes.
okay.
Big improvement.
It certainly struck me at the initial presentation as an excellent redevelopment idea.
I agree.
At a time when the city needs more residential. We don't need much more business and commercial stuff. There's an abundance of that.
Yep.
Okay.
Snow removal's gonna have to go off-site, right?
Well, we
That's
have
what I
some
was gonna
snow
ask.
storage, but not a lot, and typically, when you're in the city in urban areas like this, you're gonna have to take snow off at a certain point in time,
Right?
yes.
You'd just lose too many spaces. All right, any other questions for the applicant? All right, sensing none, I'm gonna open the public hearing at 9:10 and 42 seconds. 9:10 and 42 seconds. Are there any butters here? My goodness, and a butter, please, come up to the microphone.
Thank you, board members. Myself, Joe Alexander, my wife, Donna Alexander.
Good evening, welcome.
Thank you. We own the two houses directly across the street from the entrance to this. We own 108 and 112 Church Street, which are multifamily properties.
Thank you.
This property has come in front of the board on numerous occasions. The last time it came in front of the board, it was for somebody that wanted to put 20 single-bedroom rental units in the main building itself. I believe at that time, it was deemed that the office building was probably the highest and best use for that property at the time, which is just a few months ago. We also had concern over the population density there. With 0.91 acres, you can only have up to 5 units on a property, not 16.
Right.
So there is a huge difference in property density, which is a detriment. So the office building you use during the day, when most other people are at work or school. So now you're gonna turn it into 16 residential places where people are coming and going day and night and weekends, which disturbs and brings down the property values of my property across the street, both of my properties. You know, the standard of living, all the extra noise and everything, which is normally done at 5 o'clock by people that work in that business that was across the street. It's a complete different dynamic.
Are you located where the entrance is to the parking area? Near
Yes,
the
sir.
Building?
Yes.
And is that?
I have basically one building, 112 is here in the front, and 108 is further back, set back, and it borders the back part of Howard
Will the
Street.
driveway move? Is it gonna stay where it is?
My driveways?
No, the driveway for the.
No, it's staying exactly where it is right now,
all right,
sir.
all
Yeah,
right.
so it's basically right across the street from the main front of our two buildings. And our buildings are close to the road as well.
Gotcha.
And I think there's only one designated parking spot out in front of my building, you know, at this point. So we're adding 16 full-time families to this place. We're not saying whether it's gonna be condominiums or whether it's gonna be rental units. We're just saying, yeah, it's rentals for now. If we wanna turn them to condos later on, we will.
Sure.
You know, condos may have a better success at becoming less turnover, you know, maybe a higher level of clients and stuff due to people owning their own condos and taking care of them a lot more than the initial thing of just renting them to people. You can charge all the rent you want. New Hampshire housing normally pays almost whatever you want to pay these days. So there's nothing that states anywhere the quality of tenant other than, or the level of tenant. And again, if we just refuse 20 units, why are we adding another building that would have 4 more units in addition to, if these other 12 units, are they all 1 bedroom? Are they 1 or 2 bedrooms? Do you have an answer on that?
There's 12 units, 4 of them are 1 bedrooms, and 8 of them are 2 bedrooms. I think we did, you know, we are condominiumizing it.
It is a condo,
We
okay.
filed the condo docs, we are going for condos.
All right, I misspoke, I'm
But whether
sorry.
but whether we rent out the condos at the beginning, I'm not sure. I mean,
Gotcha.
obviously, the perfect scenario is we sell 1 or 2, and once we sell them, then we would try to sell all the condos.
Okay.
But obviously, we can't sell.
What is he referencing? You're talking about something that was submitted and not approved within the last couple of months by
Correct.
this board?
No, 1 year ago.
1 year ago?
No, it didn't come to this board because the zone was different. The zone has changed. And the 20 units was gonna be in the front building, and the fact is that it wasn't allowed in that zone to start with.
Okay, so what
there's a
happened
big
is,
difference here. There's a
in
lot
the
of changes.
interim, sir, we adopted something called performance zoning,
Okay.
which allows this board a lot more discretion in approving certain things, with the requirement that the staff do the full workup on it and research the feasibility of it and its impacts.
Okay, so
That's probably what happened.
performance zoning, is that what it's called? I'm sorry.
Well, it's a new zone too. It allows, in this
Oh,
particular
that's right.
zone, even without the
This is the new
performance
urban
standard,
commercial.
it still would allow the 16 units.
Gotcha.
The zone has changed to allow different uses.
I
that weren't
misspoke
allowed
again.
back then.
So I know you'd mentioned, well, the CVS over here, so it won't impact them, and then, there's nothing over here, it's a corner lot over there, it won't impact them. But again, I'm directly across the street, I'm 30 feet away.
Well, it
So it
seems
does
to me your
impact us.
impact is traffic related.
Traffic
You're
related,
gonna have
people in and
headlights
out,
coming out at night, and you're gonna,
noise, doors slamming all the time, yeah, all that stuff, sir.
Well,
That-
you
that
have-
increased
you have-
traffic there,
on the back of you, there's Howard Street, right?
correct.
So, how many people live on Howard Street? They're right behind that property.
Uh,
More than 12?
The people behind, no, let's see, there's 1, 2, 3, there's three or four two-families on the opposite side of Howard Street from us.
Okay. So I guess what I'm saying is, it's an urban area, it's densely settled right now, and this will increase the density of the property across the street, right?
Correct, and it also
And
increased
change the use.
the noise to the tenants in the front building that have to listen to all the additional noise and comings and goings that currently don't have to do that.
I get that.
Okay.
All right.
So to further, so if we're talking 2 units in the front plus 4, that's 20 units in the front building. And what's the back have, 4?
12, I think, 8 and 4?
Well, there's 8 units with 2 bedrooms.
Okay.
So it's 16 bedrooms, sorry. And then there's 4 units with 1 bedroom, so that makes 20 bedrooms, which would be the same as what was refused a while ago, which was 20 one-bedroom apartments. And now the 4 units in the back would have what? So now you got another 8 bedrooms in the back. So now you've gone from, 16-bedroom places or 20-bedroom places, which was refused. Now you get 28 bedrooms. That's a lot of kids, that's a lot of people.
Okay.
And you're building another whole building on that property to house an additional 8 people, other than just taking the existing use of the existing building and converting that maybe to a higher or better use. Add to that all the building structures for 16 cars to be able to park their cars there too, in addition to a bunch more. So the impact across the street is you're adding 28 bedrooms worth of people to be shoehorned onto a property that used to be something that would only handle 5 units. So there's a severe impact to the use of this property from what it currently is. I just have a couple other things.
You can take your time.
Are the garage spaces deeded to the different units? Or could the garage spaces, like, you say you're turning them into condos, so I'm assuming that the board could approve this application knowing that they're gonna be condos.
It really doesn't matter to the application itself. What the representation was, is that each unit will have one enclosed garage space.
Okay.
So there'll be an equal number of garages to the units, and whether they're held in common or they're conveyed as separate is up to the applicant.
So if they said, okay, we're gonna just rent the apartments and the people get one spot out in front of their buildings, and we're gonna take these garages, I know I can get $150 a month for each enclosed garage, I'm gonna rent those out to 16 different people.
Why would they do that? For boat storage or
For
something?
the highest amount of money you could bring in from a one property. There's nothing that says anywhere here that the garages have to be tied to the units.
It would probably be in the plan and the approvals. And they
That's
couldn't
what I'm
convert
asking,
they couldn't convert, are you saying they'd convert the garages into residential?
No, I'm saying convert the,
Rental units.
just because you have
Rent them as
16
storage,
garages
yeah.
and you have 16 apartments, it doesn't mean that each apartment is
Okay.
deeded one of those
You
garages.
could put a condition in there that ties the unit to the garages and would prevent them from repurposing the garages as storage units or something.
Okay, so,
That's something we could do.
That is our intent, that each unit will have its own garage.
And you would be happy to put that as a note on the plan, right? Okay.
right.
The reason for the garages is we're making these, we wanna make these a little bit higher end. And by having a garage for each unit is a start, stepping it up.
Gotcha.
So again, my biggest thing is just the, you know,
I hear you.
refusal of this in the past, putting 20 single bedrooms into a place that
You
now
do
you have
understand, though, that the
28.
law changed, right?
I understand, but it still impacts, it impacts that property drastically.
Absolutely.
Not only that, if you have up to 28 bedrooms worth of people on that property, that hugely impacts the level of fire service, police, any emergency vehicles, all that stuff. So a rebate on the impact fees is probably not a prudent thing to do as well, now that you have 28 bedrooms worth of people occupying a place that had none before.
Okay. All right. Well, we'll probably want to hear from the applicant on that waiver request anyway. Charlie, do you have a question
I
for
have several
this
questions, if I
gentleman?
may.
Yes.
I heard you mention tenants. Were those your tenants?
I'm sorry, which ones?
You said something about tenants having to listen to doors closing and stuff.
Yes, sir, we own 108 and 112 Church
Okay.
Street, which is right across the street from the
understand that.
entrance. I
Do-
have
do you live
tenants in
there?
that building. I do not live there.
Okay, so-
Currently.
Currently, you don't live there. So how long have you owned those buildings?
3 years? 3 years in August? 3 years in August.
Okay. And my other question is, I'm very familiar with that parking space in front of your property there.
At one spot.
I'm very familiar with it. And the reason I'm very familiar with it is Brickfront does a pretty good business there.
Yes, they do.
In their business, so much so that quite often, Mr. Chair, I can't get in their parking lot, so I look for places to park along Church Street.
Yeah.
And I wondered if, certainly, the noise that you're worried about has to be happening there on a regular nightly business, or nightly occurrence, because of the very successful business they're running at Brickfront. So,
No, we. Yeah, this is 4 buildings away, it's one spot,
I understand.
and it's not 20 cars coming in and out
No, it's actually more than that.
all day.
But again, I'm just pointing this out,
Sure.
just for reference, because to me, I'm thinking, I think somebody mentioned, this is a urban setting, it's downtown Laconia. And certainly when you bought the property, you must have been thinking about potentially a noise there, your tenants do when they move in there. I
Yeah,
just.
we
I
thought of
underst-
that as an office building, to be honest with you, Mr. St. Clair.
Yeah.
We thought of it an office building.
Yeah.
People are there 8 to 5, they leave at the end of the day.
Right.
My tenants are working or in
They-
school during that time.
Yeah, and they're
I get that.
replaced by the customers at Brickfront, who do slam doors and who can be very loud.
There's only one car that can park in front of my house at any
I
one
know,
time.
But the noise travels.
Yeah,
But
1 to
anyway,
2
Charlie
hour
usually
dinner.
takes that spot, so.
I-
Charlie, do you have any other questions for
No,
us?
that's it. Thank you very much.
Any other questions for the applicant? So I just want to say, because we're going to obviously talk about this a little bit. When the board, this board, discussed changing the zone and creating this new zone, one of the reasons for it was to encourage developments just exactly like this. It's infill development. There's existing stuff, but because of a history of use, it's been restricted to one kind of a use. So, you know, we had public hearings on that too, and they were notoriously underattended. But these are substantive changes that this board makes from time to time. There are a lot of properties within that zone that are either vacant, underutilized, or being used for a non-conforming use. And what we try to do is we get people to encourage in them to conform. This use conforms to the current zone. It may not have conformed to the prior one, that's all. And I understand your question about, well, why was it denied before and now, it's back? But it's not technically the same. It's a different manner, the performance zoning, and it's a different zone altogether. There were probably two zones here before, right? One on the Union Ave side and one on the Church Street side? Or did we combine them?
This was previously professional.
Professional, okay. So again, exactly what I just said. It allowed a change. All right, well, as long as you understand that part, because that, I think, is crucial to your objection. Public hearing at 9:25. Are there any members of the public? Oh, this is the public hearing. All right, are there any other abutters or members of the public that would like to come up? You want to join your husband or? Okay, thank you very much. We'll close the public hearing at 9:26 and 5 seconds. Saf?
So a lot of the points have been covered. So this did go to the ZBA earlier this year for a 21-bedroom type situation. As you have pointed out, and as the abutter pointed out, the zoning board did deny that application because they thought the office building should be an office building, which is, they're perfectly within their right.
And that was in the old zone?
That was under the old zone, right, when it was zone professional, and so since then, as you've pointed out, we have, A, changed the zone to the urban commercial, and B, we have instituted performance zoning, which this applicant is taking advantage of the performance zoning, which gives them some advantages, and under the master plan that we approved a year and a half ago now, this is exactly the kind of thing that we, as you pointed out, Mr. Chair, that we were trying to encourage. We have a very drastic need for mid-priced housing in the city. Performance zoning would not allow, just as a point of reference, would not allow the applicant to come in with, say, Section 8 type housing or that kind of a thing, because that would be not in accordance with the goals of the master plan. So,
Gotcha.
the master plan was very specific that if you're going to use performance zoning, it is to further the goals and recommendations of the master plan. And one of the goals and recommendations of the master plan is to increase mid-level housing for a younger age group as opposed to our typical 55-plus type situation.
Which chapter in the master plan is it? The
Land use
economic?
chapter. It's the land use chapter.
Okay.
Right. So that's how we got to the point where we are today. There is, we have a list of recommendations. There's quite a few recommendations here that are, we've got part 1 and 2 and numerous A, B, C, Ds, and Es. And there is one thing that I would like you to add somewhere on here for the condition of approval would be under, probably under miscellaneous, make a D, that we need, staff needs to review and approve the proposed condo docs,
A what?
the proposed condo documents.
Okay.
We,
That has to be a note on our
Yeah.
condition.
yeah,
So can I just ask real quick, is that a place where, because I agree with the abutter, that the last thing, and I'm sure that the applicant would agree on this too, is the last thing you would want to see is somebody who technically has a garage going with their unit, all of a sudden subletting the garage to run a storage facility there or something like that. Is there some way in the documents that
It
can
would be in the condo docs,
So
wouldn't it?
they also have to maintain their parking requirement, and if they were to sublet those garages out, they would
Right.
not meet their parking requirement.
Gotcha.
So they have to have those garages for this lot for them to meet their parking requirement.
So talk to us about the request to waive the impact fees. I think the butter makes a good point.
right.
That's
So,
20 something
using
bedrooms.
using the impact fee schedule, the applicant would be paying $13,926. It's staff's recommendation that you only grant the waiver, the 80% waiver on the units that are in the current building, and that the new building would pay the full freight.
So how does that break out?
So the total would be 83, 55, 60, as opposed to 13, almost $14,000.
And the reasoning? The reasoning for that?
The reason is because under the waiver part of the ordinance, talks about infill and reuse. Obviously, this building is, the original building, which will be 12 units, is being reused from its current empty, but most recently was an office building. The new structure is, you could qualify it as infill, but because they're doing this under performance zoning, I don't think that it meets the spirit of the intent of the infill part. It definitely is reuse on the original building, but I don't see they're getting a lot of advantages with the performance zoning. And I don't think that you need
Well,
to.
then wouldn't it be fair for them to pay the full impact fee?
The board could certainly make that decision. The request is to waive the impact fees, to do the 80% waiver period. Our recommendation is to waive the 80% on one building and pay the full freight on the new building. If the board decides to do something different, that is certainly your prerogative.
This is a one-time fee, right?
It's a one-time fee. It's collected when we do certificate of occupancy, so.
So I just, if you forgive me, Mr. Chair, but so the breakdown would be, right now, if the whole impact fee went in, it'd be 13,000 something?
Almost 14.
Almost 14. And what you're recommending, it's?
83, 55.
8,300.
About 5 off.
So about $6,000 difference, give or take.
What's the reasoning why, other than just to save $5 grand, $6 grand? I mean, is there
What's the what?
the justification from the applicant for the,
Well, the justification that it meets your standard for a request for a waiver of 80% if you're doing infill and rebuild. And
is
that's
this
the wa-
really an infill though?
Yeah, we're gonna rebuild and infill that entire building with a new use.
Okay.
I mean, that's how it's been applied in the past. I've used it before and it's been approved, and I've been instructed that that's how it should
What do
be.
you think about staff's recommendation?
Hmm?
Staff's recommendation is to apply the 80% only to the existing building.
Yeah, we agreed with that. I don't take issue with how they're applying it.
Okay,
Yeah. The new building's a new building. That's not an infill.
all right.
So you're good with what they're recommending?
Yes.
Okay.
Yeah, I think I'd be committing Harry not to, but, I mean.
Well, you are not allowed to do that.
Justification is, it meets. I don't-
Suicide is not allowed in the city council chamber, I'll let you know. Political or otherwise.
I would agree with staff with that as well.
Okay. Okay, are there any questions for staff?
Can we
somehow stipulate in the condo documents that they have to park their cars in the garage.
We could add a note to the plan, couldn't we? That the parking, that they shall not decrease the
The
parking.
garage becoming a storage area and the parking lot is overflowing.
Yeah, if every unit use it as storage, then they would not have enough parking. We require 1.5 spaces per unit. With the 2-bedroom units, you're likely to have 2 cars. Not necessarily, but likely to have 2 cars.
And if I'm running home because I forgot my book or something like that, to be told that I can't just park outside, run upstairs and get it.
No, we're not saying that.
That's not saying that.
We're not saying that. I think Mike's point is that in a lot of these situations, the garages get used for storage
sure.
as opposed to parking garages.
That would be a
And that's
change of use.
That's, no, they're saying that the tenant, if you're in unit 1 and you have garage number 1, you use it for storage as opposed to parking your car.
Then they could put that in the condo documents, couldn't they?
Right, and that would be one reason for us to
Okay.
review and approve the condo document. We want to have something in there that states garages are for parking cars and not for storage.
Does that work?
Yeah, I have no problem with that. That was our intent
Okay.
for building the garages, and again, we need the parking. If they don't park inside, we're not gonna have enough parking.
Understood.
So, and that was
That's
our
pretty
intent.
tight.
But you have parking, there must be enough parking allowed for guests, no?
They're gonna have to utilize the garages.
I
That's the only
understand
way
that, but I understand that, but.
There's another 14 spots.
There's another 14.
Another
right?
14 spots.
Is that
I
correct?
believe there's 15 other spots.
And are any of them in front of the existing building?
Yes.
Like they are now?
People
Head
can
in?
park on the
There's
street
some
and
there
walk.
and some handicap.
So if you
some
go
handicap
back for your
spaces.
book, you could probably find an empty spot there and run in and then.
Right.
So Charlie, so you wouldn't have to park across the street with Charlie.
24 spaces are required under your ordinance, we're providing 31.
Wow, all right,
So we're even providing more than what's required under the ordinance.
that's good, thank you.
Do these units have any storage space in the basement or in the attic or
no
something? Is
basement.
that slab?
There's no basement, it's on a slab.
That's all slab?
This is just a
Slab, too.
slab.
Hence the business for
We
storage
hope they'll
units in
we hope they'll
general.
live in them.
I think Bill just approves them.
At least boat storage, you mean? All right, what is the board's pleasure here?
So this would be 2 votes, one for the plan and another one for the waiver.
Right? So we're looking at the approval of the plan.
Okay, I will go ahead and make a motion for PL 2019-0142 SU and 0145 CUP, performance zoning for 111 Church Street, to convert the office building into residential units and build a new one. And I will go along with the staff recommendations, but in number 2 miscellaneous, I would like to add a D, that the planning staff review and approve the appropriate condo documents that will be associated with this new use. And, yeah, that's it.
To ensure that the
To
garages are conveyed with and
Along-
used in
along with
association
any
with.
other Along with any
unit.
other issues that may arise.
Okay.
Yeah, the use of the parking spaces and the assignment to the individual units.
Thank you.
I'll second.
There's a motion and a second. Any further discussion?
Yes.
Okay, Charlie?
I think this is great, that we're getting some more housing in the area. But with reference to, concerns about the tenants across the street, I think those are the concerns of not only tenants, but homeowners around the city. We've run into this Airbnb situation where people are concerned about all of a sudden having noise across the street and stuff like that. And if a particular, I personally think that these new homeowners will probably be good neighbors. because it'll be their home. So I would think they'd want it to be a good thing. But if there was a problem, we do have ways to mitigate that by complaints, either to the police department or the code enforcement in the city, if these situations come up. And I think, I really think it's a good thing. But I appreciate the concern across the street. But tenants, tenants are tenants, and you're gonna inevitably have some issues, but I think this is good use for this property. I really do. I wish we could get a little more of this happening around some of these other areas. I looked to what happened in Busy Corner with the Scott and Williams property there. I know there were concerns from neighbors on those side streets when that all was developed and everything there, but I have not heard of any problems per se that have been lingering in that neighborhood. So I think this is a good thing. I do. I just wanted to talk a lot because I know Kalina likes it when I talk a lot. We want to eat the time up, right? No, but I sincerely mean that.
Thank you, Charlie. Are there any other comments or discussion that the board would like to have? Well, sensing none, I shall call the question. All those in favor of the motion to approve this application, please signify by raising their hand. Opposed? And motion carries unanimously. All right, thank you very much, everybody.
Then, so moving on, I would, in respects to PL 2019-0142 SU and 0145 CUP, the waiver that has been submitted for the reduction of the impact fees, I would like to propose that we adopt the recommendation from the planning board where the 80% is only applied to the existing building and the impact fees for the new building be left intact. So that would reduce the original impact fee from $13,926 down to $8,355.60.
Is there a second to that motion? All right, is there any discussion regarding this motion? All right.
Impact fees are for a reason. I know it's using an existing building, but I just believe impact fees are there for a reason. So,
Well, and we get waiver requests all the time, and you've heard me talk about sidewalk waivers, and they're there for a reason, these sidewalk requirements, and I understand that, but this is somewhat different, because this is going to encourage increase in infrastructure. It's actually could have the opposite effect, so, and the impact fee is supposed to compensate the city for the overuse or increased use of its own infrastructure, right? So, I don't know. I don't think I have as much of a problem with this as I would if it was a sidewalk request, frankly. It's $5,000.
that's peanuts when you look at the whole project.
And so would be the full amount when you think about the actual impact that these people have. And the other thing you have to remember, is, I guess, or at least consider, is these aren't necessarily 20-some-odd new people moving to Laconia. They're people moving around in Laconia. Probably half of them already live here now. Potentially.
And I also think the fact that whether the people are there during the day for 8 hours or 10 hours or 12 hours working at a job,
right,
there's still an impact to that. So all we're potentially doing is swapping them out tonight, potentially. I mean, either way.
Well, there'll certainly be more traffic after dark across the street from them.
Yeah, potentially.
But potentially.
Could be a bunch of old people that are in by 5 and they don't leave until they go to work the next morning.
Or it could be.
I only leave for planning board meetings.
Or it could be.
Yeah, and you get home late, right?
Yeah.
Or it could be younger people that want to bicycle to work because they work close enough there and they're not going to be touching a car.
Yep.
All right.
In good weather. So.
Is there any other discussion on the motion? Sensing none, all those in favor signify by raising their hand. Opposed? All right, so we have 1, 2, 3, 4 to 1. Motion carries. Thank you very much. All right, moving along, we are at these are application acceptances. We have 3 of them here in a row. The first is PL 2018-0037 SP and 1,
It's an amendment to the original.
Oh, Amendment 1, okay, 55 Bay Street, proposal to amend the previously approved site plan. And what we're asking for here is a motion to accept and schedule a public hearing to January 7th. Do it in one motion. Anybody want to jump in on this one?
I'll make a motion to accept application number PL 2018-0037 SP and 1. I don't know if that's
Amendment.
Amendment 1.
Yeah,
Okay.
that's short for amendment. All right, is there a motion? We have a motion. Do we have a second?
Second.
A motion by Ms. Jenna, a second by Mr. Billabo. Any discussion on the motion? And this is to accept and schedule a public hearing on January 7th, right? Was that the motion? Okay. All those in favor signify by raising the hand. Opposed? That motion carries. We're moving now to Channel, PL 2019-0137 SP and 0138 CUP and 0139 CUP. Channel Lane, Winnisquam Marine. Is it in order and ready for acceptance?
Yes.
Would anyone care to make a motion to accept and to schedule a public hearing?
I will make a motion for PL 2019-0137 SP and 0138 CUP for the Channel Lane, Winnisquam Marine, to accept their application and schedule it for public hearing on January 7th.
Motion made by Mr. Belleville. Is there a second?
Second.
Second by Ms. Jenna. Any discussion? Sensing none, all those in favor signify by raising their hand. Opposed? All right. Steve, are you on one of these?
Yes, he's
So-
towards the bottom. Just keep going.
Keep going? All right. See, if the woman speaks, I just do what I'm told.
Wow.
PL 20, well, I'll fill you in later. It hasn't exactly worked for me recently. PL 2019-0142 SP and 0144 CUP, 781 Union Avenue. Why is that familiar? 27 Clinton Street. Proposal to rehab first and second floors, convert third floor to 2 residential units. This is the Odd Fellows block. All right? Huh?
I said, what if they're gonna have an elevator for those residential units?
What if?
He said yes.
They're gonna have to climb up a rope.
We need a motion to accept this application and schedule a public hearing for January 7th. Would anyone care to jump in?
I make a motion that we approve for acceptance PL 2019-0142 SP 0144 CUP for acceptance for the next meeting.
Motion by Representative St. Clair. Is there a second?
Second.
A second by Ms. Jenna. Is there any discussion on this motion? Sensing none, all those in favor signify by raising their hand. Opposed? Motion carries unanimously. Okay, now we're at new business. Mr. Trefethen, where's the Capital Improvement Committee doing? What are they up to?
I'm going to defer to Mr. Mora.
Mr. Mora, that's correct. Sorry, Mr. Mora. The Capital Improvements Plan of the City of, Committee of the City of Laconia, has it completed its task for the year?
It has completed its task through many hours of strenuous labor and going through a lot of numbers to have finally ranked each of the individual projects that the individual departments have put forward according to the standard city policies for capital improvement program items. And those items have been presented to you in 2 Excel sheets going with enterprise fund and non-enterprise fund rankings.
Well, I think it's amusing, actually, that I'm presenting it to myself.
It is a little bit ironic.
I chair both committees, do I not?
You sure do.
But you're confident that we have followed all the rules and regulations that we were supposed to in arriving at these rankings?
I believe that we have, and I think it was a very, very good process this year.
There was some interesting discussion about moving things around, because what we did was, everything was sort of scored and then ranked based on the scores. And then at our last meeting, we adjusted it to move some things up that we thought were more important than their scores indicated. But at the end, all the members of the committee were satisfied. Rob had a big smile on his face, so I guess we did our job. What we need is a motion to accept it and then forward it on to the city council, if I'm not mistaken. So, do you have any questions for staff or for me as the chair of that meeting, that group, committee? Don't look at me like that. I guess there's no questions. Does anyone want to make a motion? This would be a motion to accept the report and of the Capital Improvements Plan Committee and forward it to the city council for consideration.
I can do that as said.
All right, so moved. Is there a second?
Second.
There is a second. Is there any discussion? All right, thank you very much. All those in favor? Opposed? Motion carries unanimously. The matter has been referred to the city council. God protect us. All right. 781 Union Avenue, Steve, where the heck is that? Is that old Odd Fellows building up there in Lakeport Square?
The Opera House.
The Opera House. It used to be the Odd Fellows
Well,
block.
for those of you that were
I'm
around
old,
then,
you
I'm
know.
young, so
I still call Irwin's the Grand Union, you know.
I must say, don't take this wrong, but I am a little disappointed. I was in here at the last month's meeting to do the same presentation, and I was tabled because the full board wasn't here. And I'm looking at the members, and I don't think any of you guys were here, except for the chair. Was you here? I'm sorry, I
Sarah was here.
apologize.
She had different hair
So
colors, so you may not
I'm
have known.
basically disappointed that Mr. Bounds isn't here.
I am disappointed too, but it could not be done, apparently.
The reason I'm here is that we are asking to redevelop this site under your performance standards, and part of that is to come in with a preliminary and discuss it with the board. We've kind of done it backwards. I thought I was gonna do this before you voted to schedule us for public hearing. So if you don't like this, we won't go to the public hearing. But I have an existing, do you have the cameras on this?
We got a little carried away maybe,
That's okay.
because we were so anxious to get you up here at the podium again.
I'll share these with you while I'm putting this up. This is the rendering that has been done by the architect out in Dallas, surprisingly enough,
Dallas?
for the Opera House. Yeah, he's one of the, Peter Stewart's working on it with him. But this is a flavor of what they want it to look like. I can't tell you that it's gonna be exactly like that, because they're still kind of working through the details, but I think you'll get a sense of what they're trying to do here. The property is 781 Union Avenue is the old Opera House. It's beside our new, what's the name of it?
Chaos and kindness.
Huh?
Chaos and kindness.
Chaos and
It's
kindness.
beside Chaos and Kindness.
You mean Woolworths?
Yeah.
Oh, God.
That was the five and dime.
Well, it was the
Beside
Woolworths.
Chaos and
Five and
Kindness.
Dime was a subsidiary.
I will tell you that we have been into the planning department. We do have an administrative approval, and we are rehabbing the first floor of this facility because it's been used
I
over the
see that.
years, currently used. It's
Handsome
being
building.
rehabbed, the bottom floor is being rehabbed to house the Laconia Daily Sun.
Are they gonna have, how much of the?
I don't know the exact dimensions, but
About
it's
half.
most of it.
Most of it.
Geez, are they tearing down the buildings next to them?
And then,
No, the guy in
They're-
Dallas doesn't know
they're
they
from Dallas,
exist.
they don't know there's buildings around
They
it.
just sent him a footprint.
There is going to be a coffee shop
Big plans.
in that bottom floor,
I saw that now. Is that gonna be Wayfair?
yes.
I zoomed in.
And there is going to be a salon, a barber shop, whatever, that's gonna stay and be
You
rehabbed.
know, there used to be a barber
In the
shop on the
back?
second floor.
In the back,
Yeah, where it is now in the
where it
corner.
is now, yeah.
I can tell you that it's my understanding that the as you said, the Wayfair, right?
Yes.
it's my understanding that they are also going to use a portion of the second floor of the Opera House as part of the Wayfair, but will also be used for when they're entertaining at the Opera House.
For catering.
Can't give you the exact details on that today as we are here.
That's exciting too.
So the first floor is going under rehab. They brought in a new water line into the building, new sewer line connections. The property also involves 27 Clinton Street, which is the house that's to the rear of this. And then adjacent to that would be the parking lot for the housing, the big
Lake Village Apartments.
big apartments.
Yep.
On the side. Our proposal is to merge those two lots. They're very small.
Right.
If you look at the existing conditions plan, it's all building, parking, building.
That's all it is.
And one of the problems with the Opera House at the 781 Union Avenue, there's absolutely no parking, really. There's probably 3 gravel parking spots out back, if that.
Talk to me about the back, because right now that's where the lift access is to the upstairs.
Well, that was because they used it for storage.
Right.
That's coming out, obviously, because the Opera.
Not gonna be boat storage, is it?
Well, the second floor, the Opera House is gonna be restored. And then the third floor, they wanna put 2
Apartments.
pretty exclusive residential units
Yep.
in the top floor.
The Lakeport penthouses.
Where's the elevator gonna be?
Hmm?
Where's the elevator gonna be, in the back?
One of the things we have to do is, we do have to put an elevator in because of all the new standards.
It'll have to be in the back.
So if you look at the proposed improvements plan, which I didn't put up, sorry, but I thought
All
I,
right.
Okay, that's all
thought I
right.
provided one.
We got it.
The Opera House actually encompasses the entire lot, basically, boundary-wise. It's right on top of the boundary. And so we're proposing an elevator to the rear. That's gonna be not only an elevator, but another emergency stairway and access. It's all relative to the fire safety codes and stuff.
Is that gonna be in the addition?
Excuse me?
There's a proposed addition to the Opera House.
Yeah, that's the addition. It's just an entrance. It's for the elevator and
Gotcha.
other access for fire safety to the second, third floors.
Yep.
The proposal would be to merge those 2 lots, remove the house. The water line and sewer lines have already been removed. The water line would freeze every year, so whoever occupied that building had to leave the faucet on 24/7 all winter long in order for the water line not to freeze, because for some reason they couldn't get it down, all the utilities in there. They
The
never-
water line, the access, the input line, the inside?
Yeah,
the one in
water
the
line
ground.
to the house.
Who installs that? Does water or the
Oh,
homeowner?
Lord, that was a long time ago. I don't have any idea.
Well, maybe there wasn't as much frost.
But that's the first thing the water department told me. He says, you gotta make sure you leave that faucet on. I says, well, the faucet on where? And they said, the house. And I said, well, we're gonna tear the house down, so I don't think we wanna leave the faucet on. So the proposal is to remove that house. It's under review by the Heritage, is it the Heritage?
Heritage Commission, yeah.
Building, for a demolition permit. We've done all the work necessary and have to go through that. But the proposal would be to remove that. Currently, the access to the Opera House is right off the end of the Opera House in the back. There's a driveway in.
Yep.
And it's probably the entire length of the frontage is open, there's a driveway. And then there's a paved driveway beside the house to the, what would be to the west side. And there is a gravel driveway to the east side.
Yep.
Of the house. All that is gonna go away. We can get, I originally had 15 parking spaces, but we really need a dumpster, so we've put a dumpster in here, which eliminates one of the parking spaces, which would give us 13 parking spaces on site. We are using, Charlie, for your benefit, we are using porous pavers on the walkways in this particular area.
Because they're just walkways.
Hmm?
Because they're just walkways.
Well, yeah, because they can handle it. With a parking lot this small and all those turn-in movements, it'd get chewed up really quick.
Steve, what is the symbol that looks like a clock at about 2 o'clock?
Looks like a what?
It's a circle with a V intersecting it.
Those are the proposed street trees.
Ah,
It's just a generic symbol for a proposed tree.
I see.
We are proposing some street trees along there. And also a hedge,
Does look like
some type of a lower hedge But one of the things we're doing is we're moving the access to the lot as far easterly as we can to the end of the lot to get it away from the intersection of Union, so you don't have traffic trying to turn traffic backed up, you know, and have issues at the intersection. Right now, there's three entrances right in that very short span.
Here, you're gonna just have one opposite the
Right,
post
so we're
office.
moving it as far down as we can get it away from that intersection.
Is it directly opposite the exit for the drive-through at the post office by any chance?
No, it's further towards Clinton's Mechanic Street from that.
Okay.
access point. No.
You said that you were gonna combine the parking lots, I thought, but there's a landscape fence.
Combine the lots, combine the lots.
Combine the lots. You're not gonna actually combine the parking lot, this parking lot, with, the Lake Village Apartments, a parking lot.
No.
Okay.
No, Lake Village.
That's all
we
their
talked with
parking.
Lake Village Apartments, they have a parking problem of their own.
Right.
And they wanted to make sure that we were gonna be
They're
putting
off.
a fence up along here, so people wouldn't be parking on their side. Of course,
Gotcha.
you can't anyways, cause it's about a 2-foot
It is different, yeah.
elevation difference, and
Yeah.
all these big granite stones along there, it'd be pretty difficult, but.
Well, with the monster truck, you could do it.
Yeah,
Yeah.
with that monster truck that they
In
parked
the
over
chaos
here.
of kindness, they have one.
They have a truck that could
But
probably
you're
go
not-
right up the
Steve,
side of the
you're not-
building.
You're not, because it's hard to tell from this, but they're not gonna ask the city to do away with the parking spaces in front of that building.
No,
right?
they
would
just
like
put,
more.
just put them in.
I just wanted to be sure, that's all.
Absolutely not. We'd love to see a lot more, but that's, you know. I can
That's
tell you
very
that
problematic.
my client is working very hard to look at different avenues for parking. My client owns the property across the street at, between Railroad Ave and, help me out, you live over there,
Park Street?
Park Street.
Yeah, he owns that whole block, the old Larry's Market, all the way around up Park Street to 9 Park, which abuts me, the big white block.
Right, and I just sent a plan out to his architect. They're gonna take all those buildings down, is from what I understand.
You mean I'll get my lake view back?
Temporarily.
No, I'll tell you a true, I'll tell you a true story. I'm gonna tell you a true story. So my house was the first house built on the hill there. It's a little hill.
Yep.
And all the windows on my house faced Lake Opeechee. And then the Robies built their mansion, and they intentionally put it directly in that way, and all their windows faced.
Is that the big white house?
The big white house was the Roby mansion.
Okay.
With the round,
Right.
there's a round particle.
There's a round,
That's a
well,
different-
yeah.
That's a different plan that you're talking about.
So you're
Yeah,
saying.
but what I'm just trying to tell, they're trying to create, in that scheme, we've looked at, there's in front of Elm Street, between Railroad Ave and Park Street, along Elm Street, they took all the perpendicular parking out and put in 5 parallel parking spaces.
Yeah,
Stupid.
You can put 19 perpendicular parking spaces there.
they did that, and there's
Plenty of
2
room.
sidewalks.
Well,
There.
there's not gonna be when we're done.
Oh, I see that.
We've been to Public Works, they're on board with it. I mean, this
So we're gonna
work
get
has
the
to be done,
parking
but
back.
you're gonna be
Yeah, but
putting
it's
more
gonna be
parking
back
there.
in,
Are you saying that the
Reverse
plan is to,
No, it's not the back end.
so you can fit more in there.
is the plan to raise 9 Park, the white Roby building?
All of them.
Holy mother of God.
How
You mean
old
the
is that
street
building?
front ones too?
Every building
How
on it,
old are those buildings?
old.
You're not, how high are they gonna build up?
But they haven't got much value, let me tell you. You need to go over and take a look at them.
Oh, I lived in one of those apartments when Gilbert had it, the one on the corner there.
That's gonna be a Heritage Commission.
They're in
They
pretty
had
tough shape.
cardboard walls. They were literally
That will be a
home
Heritage
soap,
Commission thing, because they
Of
all.
course,
which is cardboard,
criteria.
yes, it will
half inch
be.
thick.
That's why we're starting that now.
Jesus.
No.
Have they
But
looked,
we digress.
have they looked at the age of that underground oil tank and done sampling around to see if it's leaking?
You
or
mean
is
on
it-
the existing conditions plan?
Yeah, well, it's also on the future plan too, it looks like you're leaving it
I
in.
apologize, it's not an underground storage tank there. The storage tank is inside the building.
Okay.
And I apologize, I didn't get that taken off. I finally got to go into the building and do some discovery and find out where things were. So there's no oil tank there to our
The tank
knowledge.
is actually within the Opera House.
Yes, it's inside, it's in the basement. Yeah.
Steve, this is exciting for me, having
So,
lived in Lakeport all my
As
life.
I say, I can't say it'll look exactly like that, but they're trying to bring it back. The circle on the top, they are gonna be putting a clock back in there,
Oh,
from what I
cool.
was told.
Yeah,
One of the changes, though, is that if they've ever been to the Opera House, upstairs, the balcony was built against the wall that faces,
Clinton.
the,
No.
restaurant,
Yes, Clinton Street.
Clinton Street. And the balcony was built right up against the window, so if you fall back in the balcony, you can go right out the window. So
Yep.
they're gonna have to change some of the windows on the side.
I think when it was originally built, there was no balcony. And the other addition that was done is that when I was a kid, there was an addition on the second floor that stuck out over Clinton Street for a projection booth.
Oh, really?
Yeah.
Well, the balcony's still there in pretty good shape.
I've been in there, and in front of the entrances, there's an upstairs lobby, and there used to be shops in there. One was a barber shop,
Okay.
so I stole a mirror from it. Little one. It was
Well,
one of those
it's
souvenir
a-
mirrors.
I think it's gonna be a pretty dynamic,
Yes,
redevelopment of that site.
it was actually a gift from the
But
current.
again, our problem is that we can't meet any setbacks. There's not even a chance of
No.
meeting a setback out here.
Parking,
And that's why we've asked to come in under the performance standards. Well, in theory, we're not expanding the building. We've had this case before in several other places where we've had to, for fire safety and stuff, put an elevator and a new entrance in, and the planning board didn't count that as an expansion of the footprint. So if you don't expand the footprint, you don't have to add more parking.
correct.
Unless you can. In this particular case, it only makes sense in our mind, everybody's starving for
I
parking.
think the city needs to be more involved in ensuring off-street parking in Lakeport Square, because we need to take some of those on-street spaces to widen that intersection. And they already did actually take some.
Yeah,
And, because there's off-street parking down below in the parking lot where O's Restaurant is.
Not for public.
Concept.
Some of it was supposed to be
Well, I know, we
dedicated to
had that
public
discussion,
use.
and I tried to find that.
no, it's all private.
And I went in.
I was on the board, we made that, there was at the time that the bridge construction, state was doing the bridge construction, and they put all that iron fencing up.
Well,
And that's why they built the stairs from where the warehouse trail is down below.
no, we built the stairs. Wild Trail built the stairs from the parking lot up to the Elm Street.
They were supposed to though, on the original approval.
But
And there were stairs further
They
down.
also, I reviewed the files. I couldn't find anything where they were gonna have public parking,
Okay.
but that section of gravel parking area, as you go down is it Doris Drive? Or-
Doris Drive, yes.
Yeah, on the right, they had designed a parking lot in there, but never built it. I don't know if that was gonna be public or what. But they had a layout of parking on that side, so. But
Okay.
parking is a premium.
Oh, I
in
understand
area.
that. I understand.
So,
that. But I mean,
I tried to
my
come in
point was
here-
the city needs to be more involved in that.
Yeah. I tried to come in here last month so that we could get the vote on public hearing for next month, which you've already done, and,
Yes, I remember you left in a huff,
no, I did not.
kind of a huff, a
I
semi-huff.
did never do that.
You mumbled.
Well, that was mumbling to myself. It
Oh,
wasn't
okay.
huff.
That's just because,
Hey, you know, you win some, you lose some.
Conceptual plan.
It's the way life is.
you're a good
So-
man, Mr. Smith.
so-
Any questions?
Can I jump ahead and make a motion that we approve this conceptual review and move forward with this, since we already
Absolutely.
scheduled a public hearing for it?
I think we can.
Okay, I would like to do that. I make a motion to accept the conceptual review for 7081 Union Ave as presented before the board tonight, and move forward with the already scheduled public hearing on January 7th.
We have a motion by Mr. Bellevue, second by Mr. Chen. I have a question. So there's still gonna have to be another vote after the public hearing to give the final approval. So what will be presented to the public, the conceptual plan or the final plan?
No, I've got
Final plan.
final
Final
plan
plan.
with the CUP.
So we just gave you the green light to bring the final plan in, which staff hasn't seen yet, right?
No, they've seen it.
You've seen it. And then the public hearing will be your presentation on the final plan. Okay, good. Excellent.
Thank you.
All right, we have a motion and a second. Do we have any discussion on this motion? Are you eating your glasses?
I'm getting hungry.
Okay, man.
He's starving
Listen, I have a
everybody.
pen here, it's really tasty.
Might have so many of these. Do you need one?
Yeah, we got no donuts.
Yeah, where are the donuts, Charles? All right, all those in favor signify by raising their hands. Opposed? It's unanimous. Lakeport Square is getting a facelift. Yeah, just in
Oh,
time.
losing all its blood.
You have, all of you, you should have a schedule of your meetings for next year, 2020, courtesy of Kalina. Is there any old business? Wait a minute, we just did that. That was the old business.
We still need to approve your minutes.
I lost the last page of my agenda.
That was the very first page.
Should you decide to approve them?
Okay. So that was it?
That's all you missed.
That's all you missed. You skipped
I make a
one.
motion that we approve the minutes from the November 6th meeting.
Okay, there's a motion to approve the
Second.
minutes. Any discussion? Sensing none, all those in favor signify by raising their paw. Charlie, are you
Abstain.
opposed?
I wasn't here,
Well,
so I'll abstain.
neither were they. You don't have to abstain.
Well, I can't, how can I approve the minutes if I wasn't even
Oh,
here?
my God. All right, the motion carries 4 votes, and abstention doesn't count as a vote against. So,
Well.
conscientious objector over there.
No, I wasn't.
Okay, that was it then. Do we have the final motion of the evening, perhaps?
No, don't we have new business?
Do we? I lost the last page of my agenda. I don't know what I did with it.
Somebody needs to make a report.
Somebody needs to make a report.
Planning Department report.
Ah, you found it. Planning Department report.
Okay,
Thank you, sorry.
so I'll make it
You
very
weren't
brief.
helping me there.
I'll make it very brief.
Okay.
I just want to point out that tonight with 111 Church Street was your first performance zoning application approval. And I really thought that the Opera House was going to beat you, but it beat that one, but it didn't. And as you've heard, we have some others that are in the works.
Yep.
As well, so it's pretty exciting. And with that, I will.
How did it work out? I mean, were there any problems that staff encountered in doing it, or it's a different way of doing
We
business?
have we're gonna wait and see, but we have a potential issue with the new setback requirements in the UC zone, which also apply to the performance zoning, that, because we're using an averaging of the
Right.
2 adjacent lots, and that may or may not
That
work
was
out.
brought out, I think,
Yeah,
tonight.
that may or may not work out, so
With a
we may have
vacant
to.
lot, right.
We may have to tweak that a little bit or reformulate that, but we'll bring that to the board.
Tweak it.
But other than that, no, I think that was an excellent project, and is exactly the kind of thing, as you pointed out, Mr. Chairman, exactly the kind of thing that we were hoping to spur in the city.
Yep.
And I do understand the butter across the street and his concerns, but
Yeah, but he,
They could do a lot worse.
yeah, absolutely.
it's an urban zone.
It's an urban zone, it could have been anything, it could be a restaurant, you know? So, all right. Anything further from planning?
No.
The only thing I'll say about LRPC is that we were supposed to have a meeting Monday, but everybody lost their minds. They thought this was gonna be a terrible storm. What did we get, 2 inches?
End of the world.
And it was supposed to, oh, I know what happened. It was, we were gonna have an informational session, and it was gonna be at the college, and they must have closed the college, because everybody lost their mind Sunday night.
They did close the college.
It's just
Not all of
crazy.
us. So they postponed it to.
You lose
next
your mind every
Monday.
day.
Yep. Next Monday, be there, be
I've seen
square.
you walking around looking for it.
I'm not
All
sure what
right.
I was looking for.
So next Monday, you gotta go.
Is it next Monday?
Yes.
Yeah, the original email was not correct, but I did get that in my calendar. All right. All right, there's no one here from Conservation or the City Council. Is David all right? Does anyone know?
He's gonna live.
Oh, damn.
Resting.
Okay. So here we are, with other business and adjournment.
Oh, new business, I have something, I just wanna, if I may, Mr. Chair,
Of course,
thank you.
Representative St.
I
Clair.
just, the sidewalk thing really bugs me. And it bugs me because I think as a city, we've neglected an area that really needs a sidewalk, because we keep thinking, well, there's gonna be development, we'll get these people that are making the development to put the sidewalk in. And that's Weirs Boulevard. And Weirs Boulevard it's astounding, and I think it's just dumb luck that we have not had a pedestrian hit there. And I'm not talking about bicycles, but I'm talking about pedestrians who end up having to walk in the road at nighttime.
The city would have to spend almost as much money as they did this summer, because of, we wanna add a bike lane too, right? Bike lane and a sidewalk?
I'm just talking,
I know you're talking.
just saying that whatever the cost is, the city, it's the only way to get from Lake Street to the Weirs. And we have so many people that either reside on that road or rent homes or have to get from point A to point B, especially in the summertime. We don't have public transportation, and so people, if they can't get a ride, walk. And I'm just thinking that whatever the cost, I just think that the city is amiss saying, well, we'll wait till the area is developed. The area already is developed.
I agree with you.
So I'm just putting it out there as a matter of
How far
public,
down Weirs Boulevard would you wanna go?
The whole length of
the
it.
whole length of it. And I'm just.
Especially if we can't build the WOW trail on the other side of the lake, we would wanna have some pedestrian.
Where's Beach to where?
Shaw's, the grocery
Yeah,
store?
that's to Lake Street. And absolutely, I think that the city has a responsibility. Now, I'm not sure if there's federal grants, I'm not sure about any of that stuff. And yes, I did say when we had that discussion about ripping up railroad tracks and stuff like that, my suggestion is that the east side of Pelagus Bay looks just as beautiful as the west side of Pelagus Bay for pedestrians or people walking. So they could maybe incorporate the sidewalk to make it whatever, and just say, hey, this is the WOW trail, or a walking trail. You know, I'm just thinking, I don't think I'm thinking out of the box, because I hear a lot of people saying, why don't we have a sidewalk on this road? Why do we have these little segments of where there's a sidewalk? That's all I'm just talking about that, because I think the city owes it to the residents and our visitors to have a sidewalk there. That's all. I'm just throwing it out there as a
I
matter
think
of
the chair would agree
commentary.
with that.
We have a sidewalk on my street that's not maintained, so the kids ride their bikes in the street anyway.
Well, technically, you're not supposed to ride your bike on the sidewalk.
And or the kids have to walk in the street, and every year I have to contact the water department, because it's their property.
When you say it's not maintained, they don't plow
Japanese
it?
knotweed
Oh, my God.
grows
Where is
over
that?
it.
Where is that?
Lafayette Street.
Yeah.
The waterworks where the old
Oh,
water
yeah,
tower
yeah,
used to
yeah,
be.
yeah.
Oh, I
There's a
remember that.
sidewalk that goes
I
up
just
the
drove
street.
down there. That road is awful.
To the, yes, that road is
Lafayette
awful.
is
But you
terrible.
know what? Right now, it's good. Wait until the spring.
Yeah, yeah, yeah.
You get extra points like the rodeo if you kick your feet when you go
Oh,
up
I
it
know that, I'm
and stuff.
familiar with that.
But
street.
anyway, so the Japanese knotweed grows all over the thing, and the grass and the bushes grow up, so the kids can't use that anyway.
Yeah.
But they plow that twice as much as they plow our street.
So Charlie,
okay.
the Capital Improvements Plan Committee did move the sidewalk, budget up in priority. We didn't
You
touch
know, we
the
made a
amount,
comment about it, or I made a
but
comment about it.
we moved it up. I do remember saying that.
So if I may,
Sure.
It doesn't matter.
I mean, if it's the board's desire, staff could take on the task of trying to get a specific line item in the capital improvements plan during the next cycle, next fall, specifically for the Weirs Boulevard
about this?
sidewalk. Now, I'm not saying that
We
we
need
should
like
do
a
it in.
feasibility study and
Well, yeah, I mean, I'm not saying that we put it in the capital improvements plan for the year, for 2021. I'm just saying that we put it on the list and
there would be
in the out
probably
years, and you could do.
100 parcels that would need to be taken by eminent domain. There's extensive ledge there that would need to be blasted, right next to motels and cottages. That property was originally all pasture land. And then they threw the road across and they separated the pasture land from the lake, and they developed the lakefront. There's cow tunnels.
You know,
There were cow tunnels under the boulevard so that the
regard-
cows could get to the water.
With regards to the ledge, I mean, I get that, but you know what? We put 93 right up through the White Mountains, through a lot of ledge, and,
Yeah, but you don't have to blast right next to somebody's,
well, you don't have to
property.
necessarily, they blast.
Make a floating walkway,
No, listen,
draw lots of people.
they blast to save money from just
the
drilling.
lakefront people would go nuts. You kidding me?
Mr. Chair, they blast to save money so you don't have to drill. So they wouldn't necessarily have to blast. They could drill it and chip it away that way. You know, there's just ways to do it. And I'm just saying that I'm just stunned
But
we haven't
Charlie,
had multiple fatalities on that.
I
that road.
absolutely agree with you.
I know you do.
But what did Wes say? Yeah, they can barely get $1 million or $2 million a year just to maintain the existing streets.
This would have to be
This would be a
something-
$20 million
This
project.
would have to be something where somebody would have to get, inventive and look for grants, federal transportation money, of which we all pour money in and get very little back in this state as compared to other states.
Well, it is
And-
United
and-
States Route 3,
So,
5,000.
right?
Yeah.
It's US Route 3.
yeah, no, but it's urban compact. So, in any event, it's something
No,
that-
the urban compact ends at Shaw's.
No, it does not. It goes all the way up to.
The Weirs?
Yeah, that's right.
Yeah, the
Whole
city
boulevard
maintains
is
all
urban
that.
compact.
There used to be a sign at the McIntyre Circle.
Yeah, the Guilford part of
Oh,
whatever that Lake
Lake
Street
Street.
is,
Gotcha.
because Guilford's a town, so
no,
they.
I know. I used to work at the Margate as a night auditor, and we used to have to call the Guilford Police if it was across the street at the end.
Right.
Yeah.
But that's urban compact, but nonetheless, I just want people to start saying, hey, let's look at this and see what we could do. That's what they did.
Great idea, Charlie.
That's what they did with the sidewalk that goes up along US 3, up, across from Pharaoh's there. That was a
Yeah, we
big
could
deal
have
getting that
Wes put
sidewalk.
that on.
So,
And that, we could
so I don't think we need a motion, because
No,
we've
no,
heard that
no,
the
no.
staff,
For the feasibility
the
study.
staff is going to look into it and get back to us
I
on
plan
that.
to
I
make
think
a
it's an
second
excellent idea.
City council.
We gotta find some creative ways to increase the infrastructure in this city without having to shift the burden onto the taxpayers. And we have a tax cap too. So,
No, I think they're, like you just said.
creative ways. And you're right, there may be grants out there, but what it needs is that we need the city to dedicate the manpower, or woman power, to get that done.
Staff power.
Staff power, people power. All right, is there anything else that the board could possibly ruminate upon this evening?
I apologize for not bringing
I'm
donuts in
hungry.
Yeah, we're all hungry.
next time.
Maybe pizza or something. All right, so a motion to go home and eat?
I make a motion,
First and
yes.
second.
So
First, we
moved,
have to
so-
adjourn, that's right.
So moved.
Motion to adjourn, is there a second?
Yes.
All those in favor say aye.
Aye.
Raise your hand,
Three.
stamp your feet if you're happy.
You gotta force all of the utility companies to put the utilities underground in tunnels that are also walkways for maintenance.
Oh, there you go.